The urgency for today. It will come.
Training, page number 6, final reading matters number 34 and 35.
Without informing, why did you take an adjournment? Correct. She has to wait the whole day, right? When you take an adjournment in the morning, you have to inform the other side. Then don't make a mention. Reach other ಹೇಳಿ. If you don't find the other side, ಆಯ್ತು ಹಾಕಿದ್ದೀರಾ? Put up ಮಾಡಿಸ್ತಾರೆ. Argument merits ಮೇಲೆ ಮಾಡಿ. What is that? ಮಾಡ್ಲಿ. ಯಾಕೆ ಇವತ್ತು ಯಾಕೆ ಮಾಡಲ್ಲ? ಇಲ್ಲ IA ಆಗ್ಲಿ, we will consider it is for us to consider. ನಿಮ್ಗೇನ್ ರೋಲ್ ಇದೆ ಅದರಲ್ಲಿ? ನಿಮ್ದು ರೋಲ್ ಏನಿದೆ ಅದರಲ್ಲಿ IA ನಲ್ಲಿ? We will consider discharge alva. Mr. Consul, don't give reasons for adjournment, okay? The other day also you mentioned, you knew this matter. What was it? Other side was pressing. And in spite of that, you don't even mention to the other side. And then you take an adjournment in the first hour. Is it proper on your part? Whole day they have to sit for a matter. Correct, Mr. Consul? Then you should come and make a submission that I could not inform. That's why we don't give any adjournments at 10:30. Do you understand that? You make the court to do some wrong orders. Is it proper on your part? You come, we will hear this matter. Karkon banne nim senior na, yarna karkon banne.
Page number 7, serial number 36 to 41.
Serial number 39, my lord. I appear for the petitioner. I have informed Madam Nandita Aldipur also. Maybe taken up
respondent number
immediately
1
after-
Yes, madam.
It can be
What?
taken after vacation, your lordship.
At request of the petitioner counsel. This matter after on ensuing Dasra vacation 2024.
Madam, interim order may kindly be extended.
Interim order granted earlier is extended till the next date of hearing.
Page number 8, serial number 42. This one, for being serial number 1.
Yes, what is this? Settlement agidya. Parties are present. We will take immediately after the orders. Preliminary hearing mugud mal tagodu. What is this being took? Who is the respondent? Whose name has to be shown? Kasturi Senior Counsel for Mohan Kumar anta ide. Mohan Kumar bedva? Sorry. Orders on being spoken. Who was the advocate on record? The orders on being spoken. It is got to the notice of the state that the counsel on record name is mentioned as Mohan Kumar. But the counsel on record is Srimati K. Ananthi. Light of the same, the registry to show the name of Srimati K. Ananthi in place of Sri Mohan Kumar. And after doing necessary correction, to release the to furnish the certified copy.
Final, serial number 2. File.
My lord,
Yes, madam. Shown.
the petitioner, my lord, similar matters subject to deposit of 50%.
Issue emergent notice to the respondent. scale of the given order, subject to the petitioner depositing 50% of the award with proportionate interest within a period of 4 weeks for the trial court. Yes.
Much obliged, my lords.
Yeah, writing.
But similar matter have been disposed of. Will disposed of both the council submit that in identical matters, the coordinate bench of this court in WP 881 of 2024 has directed the BESCOM to sanction permanent in connection. The such submission is recorded, and in light of the same, the petition is disposed of in similar terms. And this court passed the following order. The petitions are allowed. The petitioner are at liberty to submit application in prescribed form. Respondent number 3 for sanction of permanent power supply along with the requisite fee, and if such applications are submitted, the respondent number 3 BESCOMs to consider the same and pass appropriate order in accordance with law. Next, this court, it is made clear that this order is subject to the outcome of the final result in pending the petition in WP 22050 of 2020.
We have filed various petitions. The petition is filed after 6 months. Our names are not shown.
So you enter appearance to take notice for the regional transport 1 na Neva. SCGP to accept notice for respondents number 1 and 2. And Bhandari for respondent number 3 na. And you appear for? Will you file an application? Harish Bhandari to accept notice for respondent number 3. Petitioner counsel to solve the petition cases. Raise this matter immediately after the ensuing Dasara vacation 2024. Similar, Ade alva? Yes, Devraju. Similar. 1 and 2 ಗೆ ಇಬ್ರಿಗೂ ಅಪಿಯರ್ ಆಗ್ತೀರಾ? HV Devraju to accept notice for the respondents. A week's time is granted to file wakala, the order sheet. Next. Both the council submits that in identical matters, the coordinate bench of this court has disposed of the writ petition. Numbed order ಎಲ್ಲಿದೆ? Same layout, the petitioners have acquired the property bearing site number 246 and 794. Layout formed out of assessment numbers 52, 53, same, 56, 57, 58 and 59. Village Panchayat Khata number, old 42 na. House list number same, 246 and 794. Correct. Assessment numbers anta. The layout formed anta ಹೇಳಿದ್ರೆ I think the petitioners have acquired property bearing number 246 and 794 layout formed out of survey number 52, 53, 56, 57, 58, 59. And village khata number old 42, house list number 246 and 794. Situated at Shigehalli village, Yeshwantpura, Hubli, Bangalore North Taluka. Through registered sale deed, through registered gift deed and sale deed, and pursuant to the deeds executed, the petitioner's name have been entered in the revenue records, and the petitioners have obtained approved sanction plan and carried out construction over the site by obtaining temporary power connection. After the construction, the petitioner has sought sanction of permanent power supply power connection for their house. And the respondent number 2 issued a letter stating that the permanent electricity connection cannot be granted to newly constructed site situated at survey number 52, 53, 56, 57, 58, and 59. It is brought to the notice of this court that the vendors of the petitioners were issued with a show cause notice stating that the vendors have formed unauthorized layout in contravention of the provisions of the Karnataka Town and Country Planning Act and Bangalore Development Authority, challenging the show cause notices. The petitioners vendors have approached this court in WP 22050 of 2023, and this court wide order dated 4/10/2023 directed the authorities not to take any corrective steps. The dispute as to whether the petitioner have put up construction in the unauthorized layout is placed before this court in WP 22050 of 2023, and there is an interim order operating, directing the VDA as well as the Tahsildar not to take any precipitative action. Such being the case, the interim orders issued by the petitioner by respondent number 2 cannot be given effect to, and the respondent number 2 is at liberty to take appropriate action subject to the result in WP 22050 of 2020. Learned counsel on both sides have been identical matters in WP 881 of 2024 and other connected matters. Some of the layout owners have approached this court seeking similar prayer, and this court wide order dated 21/3/2024 allowed the petitions with direction to the jurisdictional DESCOM office for sanction of permanent power supply to those petitioners, which would be subject to the final outcome in the pending WP 22050 of 2023. And the present petition also needs to be disposed of in the similar terms accordingly. This court passed the following order. The petitions are allowed. One day, na? Which petition is allowed? The petitioners are at liberty to file application in prescribed form with respondent number 2 for sanction of permanent power supply along with requisite fee. And if such applications are submitted, respondent number 2 must come to consider the same and pass appropriate orders in accordance. It is made clear that this order is subject to the outcome of the final visit pending in WP 22050 of 2020. Date of the disposal pending IS, if any, does not survive for consideration.
My lords, I appear for the petitioner, my lords, in serial number 6. I'm on VC, my lords. My lords, I'm challenging a demand notice. My lords, the demand notice is at page 59, annexure A. My lords, were to peruse the demand notice, there are 3 things, my lord, which my lords will notice. One is that, my lords, it says audit akshepane mottavannu sarkara pavitru. That means if there is an audit objection, based on the audit objection, you have to pay this much amount of money. There is no demand notice issued to me. There's no show cause notice issued to me. There's no hearing. Without any hearing, they've passed this order. That's the first point. Second point, my lords, is that
notice, Mr. Counsel, it's not an order, it's a demand notice. You have to file an objections to this.
No, my lords, no, it's a direct payment of demand. It's a payment of demand. They're saying pay this much amount of money. They are not asking for explanation. The matter has to be heard before they are asking for insofar as five aspects are concerned. They are saying there's a demand notice. I'll just read it entirely. ಆಡಿಟ್ ಆಕ್ಷೇಪಣೆ ಮೊತ್ತವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಪಾವತಿಸಲ್ಪಟ್ಟು ABN ಇನ್ಬೇವ್ ಮಾಲೀಕರು ಟಿ ನರಸೀಪುರ ತಾಲೂಕಾದ ನಿಮಗೆ ಈ ಮೂಲಕ ತಿಳಿಸಿಕೊಡುವುದೇನೆಂದರೆ ಮಹಾಲೇಖಪಾಲಕರ ಕಚೇರಿಯಿಂದ ಅಬೆಕಾರಿ ಉಪಾಧ್ಯಕ್ಷರಿ ಕಚೇರಿ ABN ಇಂಡಿಯಾ ಲಿಮಿಟೆಡ್ ಮೇಲೂರು ಟಿ ನರಸೀಪುರ ತಾಲೂಕು ಇಲ್ಲಿನ ದಾಖಲಾತಿ ತಪಾಸಣೆ ಮಾಡಿದಾಗ ಸರ್ಕಾರಕ್ಕೆ ಪಾವತಿಸಲು ಈ ಕೆಳಕಂಡ ಆಡಿಟ್ ಖಂಡಿಕೆ ಬಾಕಿ ಇರುವುದಕ್ಕೆ ಆಕ್ಷೇಪಣೆ ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತಾರೆ.
ಅಲ್ಲ, ಇದು ಡಿಮಾಂಡ್ ನೋಟಿಸ್ ಅಂತ ಹೇಳಿ ಡೈರೆಕ್ಷನ್ ಯಾಕೆ ಕೊಡ್ತೀರಾ?
It's covered by a division bench judgment.
When you issue a demand notice,
To kindly take my colleague will just pass on the authority.
you should ask them as to why coercive action should not be taken. We directly say, please pay that amount. PGP to accept notice for the respondent. For the petitioner submits that the impugned demand notice issued by the respondent is clearly based on the audit query raised by the Accountant General's Department, and the report has not yet been finalized. In spite of this, the demand notice, in the guise of the demand notice, the respondent has quantified the amount payable by the petition in the circumstances made out. Further, the respondents are directed not to take any coercive steps pursuant to the impugned demand notice at annexure A, subject to the petitioner depositing 50%
My lords,
of the
just
demand
make one submission on that.
amount.
My lord, just make one
Deposit
submission.
before this-
My lords may kindly deposit before the court. My lords, on that aspect, my lords, there is division bench judgment which says that based on a CAG, demand notice itself does not lie. My lords, I have not even been heard in this matter. Without hearing me, they've passed an order. My lords may kindly look at the list of authorities. May I just pass on one judgment, my lords. My lords may just look at the list of authorities.
That is always a final outcome of this petition. You deposit before this court.
May I request for
50% to be deposited within period of
20
4 months.
25%? May I request for 25%?
25%. You've already passed an order, 25%.
Ready?
Yes, question. The time Mogadmala you are seeking for this.
1999. When I took in from CL9, he suffered a current fix. Whether I was another check, just because my lords are follow the last direction issue when you send the report. 99, he executed the power of attorney. However, the license was discontinued on account of the fact that the landlord of the building survived. Subsequently, the petitioner's wife, who is the power of attorney holder, has been doing without the post. Directions are issued repeatedly to consider. Last election,
Now, what is the endorsement issue? Annexure R?
no matter after this latest direction, annexure P is the last order, these are the report page number 71. Operating portion is page number 73. There are 4 and 5, there are 3, yes, ma'am. Accordingly, page number 75. Accordingly, petition stands disposed of. Granting liberty to the petition to submit an application to the prescribed form as stated under Rule 4B, 1B rules, along with the prescribed license fee and also relevant documents. It is not already furnished with the report number 4. It is 2 weeks from the date of the upon receipt of the application to be submitted to the prescribed form, respond number 4 is consider the application strictly in terms of Rule 5A of the rules and not appropriate order to the record of the beginning of the rule 8 weeks. However, I will comply with the order and schedule page 76 is a fresh application made on 5 May 2024. Thereafter, my lord, one direction is endorsement has been issued. To accept that, page number 78, then you have to issue a samajistic the Gopal ತೊಂಬತ್ತೊಂಬತ್ತನೇ ಸಾಲಿಗೆ ನಮ್ಮ ಒಂದು ವಿಜಯನ ಸೋಲಿತು ಇಪ್ಪತ್ಮೂರು ಉಳಿಸಿ ಹೋಗಿ 24-25 ಮಂದಿ ಇಲ್ಲದ ಒಂದು ಸೂಚಿಸಿದ ಮೇಲಧಿಕಾರಿಗಳಿಗೆ ಸಭೆಯನ್ನು all documents have been furnished. Right from all academy also they are accepted as all academy and they say that you bring the original. You know, original cannot be taken either your memory is either there in the HI office or in the bank. Because she is not able to lay the hand. But in the earlier directions also it is accepted. At the most they can even visit the house and see the condition of the implement is alive. And such a very unpleasant way they treat you very. This one day before this petition, I felt so bad. One officer tells her that your husband dies shortly, then you get it as a legal which way you will first time this kind of advice, madam. So my direct submission is there is no room for me disqualification. He is alive. He is not insane. That has been decided by there is no dispute.
Why are you insisting all those documents from her? Wait. 8 weeks ಮುಗಿದೋಯ್ತಲ್ವಾ? Correct. There's a direction by this court to dispose of her application within the period of 9 weeks. You keep on insisting some or the other.
Therefore, may not be directed them because this is not having. Therefore, may not we have directed them to produce the original GPA. Okay, by this already covered it makes sense.
Original GPA. This will all keep on pending here. Unnecessarily it will be pending here. To consider their application, you keep on answering. SCGP to take notice for the respondents. All the respondents, copies are served on you. This matter immediately after Dasara vacation 2020. Yeah, the taking of notice by the SCGP does not debar the authorities from considering the application of the petitioner which has been filed in accordance with law. Process andre, it should come to a conclusion. Yes, yes.
Appearing on behalf of the union, my lords.
As he filed his objections.
My lords, I seek for a passover, my lords.
Passover.
To 3 p.m., my lords, if your lordships can consider.
What is that?
Would your lordships kindly pass over to 3 p.m., my lords?
Passover.
Yes.
Not at 3 p.m. Passover. It will be called.
Number 9. Upamurthy.
Yes, Mr. Onkar Murthy. What was their application? What was the application?
From the practitioner. The second thing is the power of attorney which is executed does not authorize the same execution training that please come to. I read a lot of invitation to paragraph. Paragraph page 66. They cannot find a way to try the part of the importance of attorney. I want to find out what is the irregularity. Permit between the paragraph 2. Our authority shall be and attorneys enforce and execute all agreement of their deed. Negotiate and agreement of their deed, not their deed.
That is all the question that has to be done.
The second thing is the subject of order. 108. I know that a very significant one, but material one. That by the time to page 108.
Yes.
I'm reading the Adesha. Telanka Taluk Pratigata Secretary of Sarve Revenue Prataka. Telanka Taluk Company. This was ideally Mandur Malai. After revenue,
There is alternative, no, senior counsel, there is alternative remedy available against the order of the
But then nothing to do with it. And it, one case is a grant made after 1913. Therefore, tax.
But then this Lakshman Gowda's case, Lakshman Gowda's case and this Shabir, Bashir Ahmad's case says, if a sale is there between 1963 to 1978, correct, and if after 78 the grant has been granted to the original owner, then that inures to the benefit of the purchaser.
Feeding the grant.
Feeding of estoppel.
Common law.
Yes.
And when my present case, the case is really lost but not well off. Other than that, somebody can do Kandaya Jashi. To bring Sarkara. It is Sarkara net.
This is after so many years. 2010 is the 10 is the if at all you are aggrieved by that power of attorney and all, you have to approach the civil court. We will ask them to take notice.
Maintain status both the parties.
Was there any benefit of status quo order after the purchase of the use of the you can move the petitions. You can, you know, senior counsel the scope of not to say anything more. Not in this matter.
Second thing is phone number, therefore I thought, ultimately the phone match with the relief and refuse to take the relief. Here is the case where the grant is subsequent to 70, therefore I am appealing.
Yes. CGP to accept notice. Let them come, we will consider. Senior counsel is that. If there is a 15 years non-alienation clause, he has to file an application within that period. No, nothing like that. CGP to accept notice for respondent number 1. Issue emergent notice to the respondents, returnable by, we'll fix a date for it. Returnable by.
Action to be taken.
What is that precipitative action? They are in possession of the property.
Well, I expect it paper.
Take your after the note, service of note. Yes. Yes, Sima, what is this about? What mandamus, what is the representation you have given? Reconnector. You were given some connection earlier? When were you given connection? 20? When were you given this 20 HP? Yes, which is that order of connection for you? Exhibit. I mean, which is that annexure? Annexure C.
Page number 31.
Page number?
You open the connection.
This is a test certificate. What is this test certificate? Connection ಕೊಟ್ಟಿದ್ದೆಲ್ಲಿದೆ? When you are seeking for reconnection, There's something called connection before that. Yes, you would take, tell Devraju, who is the counsel appearing? Devraju, na? SCGP to accept notice for respondent number 1. The HV Devraju to accept notice for respondent number 2 and 3. To get him, will pass. Or Karkon Banile. Get HV, passover. Get him here.
Orders.
The settlement table. Settlement terms. Joint memo, na? Party is present. ಒಪ್ಪಿದ್ದೀರಾ?
Union is the party. They are signed there before the registrar. Registrar has
The settlement is what? Who has raised the dispute? Sabita Pujari. And who is he? General Secretary of the union.
Who are signed the same statement.
And what about that lady, Sabita Pujari? Because see, ನಾಳೆ ಬಂದು ನಾನ್ ಬಂದಿಲ್ಲ, ನಾನ್ ಸೈನ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ರಿಜಿಸ್ಟ್ರಾರ್ ಮಣಿಪಾಲ್ ಅಕಾಡೆಮಿ ಹೈಯರ್ ಎಜುಕೇಶನ್ ಇದು. Before whom she has signed? Registrar of Respondent. What was the charge against her? Dismissed from service. Now towards full and final settlement, 5 lakh rupees is being given. Check is already handed. At least she should have been present through online, Alba. Why online agalla? Ask her to be present online. Just online VC connection kodi avರಿಗೆ. Why? What happened to her? ಅಲ್ರಿ BC ನಲ್ಲಿ ಹೇಳೋದ್ ಬೇಕಂತಲ್ಲ, ಅಲ್ಲೇ ಕುತ್ಕೊಂಡು ನೋಡ್ಬೋದು. ಅಷ್ಟ್ ಮಾಡಿ. That Mr. Somshekar, let them come through VC. 2:30. Bani. See, we don't know. She must have signed before registrar. Let she come through VC, we will see her. 2:30. You are giving DD also. You are giving her DD amount, right? Of 5 lakhs. Next.
Orders. Cell number 11. Anmohan PA.
What is this? Who has moved this petition? What was the urgency to move? Admit. Appeal is admitted. Then, in vacation, what will happen? Will the FDP be closed? 2110. 2110 is when? What is the urgency for you to move this last day? Is it not? You kept quiet from 2016 to down to 24. Right. How can we pass any orders without admitting the appeal? Is it not? Is it not, Mr. Counsel? And 21st, so you take a chance. 21st, edukide for what it is. Report admit immediately order agatta illa. You have to file objection for that. So counsel, not without admission. We will see if there is a case for admission. Petitioner is granted a week's time to pay the process. You have paid? When did you serve? Why 2 appeals?
Could I have filed one seeking for party declared, my lord, have filed a regular appeal, and then litigation.
Now your suit has been, what happened to your suit then? Before the first appellate court?
Is
Partly dismissed, partly allowed. Your appeal is dismissed. Before the trial court, your suit was partly decreed, right? So against that, you wanted a full decree in your favor before the first appellate court. First appellate court said, no, you are entitled to only partly decreeing of your suit insofar as certain properties are concerned. Is it not? Now, who has filed the FDP?
the defendant number 3, Lord, she claims to be the wife of my father, my lord. But she is not wife, my lord. I am accused.
You are the plaintiff, right? Your suit for partition.
It will be clear what I said that defendant number 3 is intended to by name same, my lord. But she is not the wife of my father, and she is not intended to any age. She, her husband is there, my lord. They have produced a certificate of
Now, just a moment, Mr. Counsel. FDP must be filed only in respect of a scheduled property for which you are seeking for share. They cannot seek anything more than that, right? Was their suit, first appellate court, did it decree their suit? What did the first appellate court do? Then. Correct.
And she is intended for by right said the property belongs to the defendant. Based on that,
Your father is not alive, right? And who is defendant number 1?
Defendant number 1 is the husband. During illness, suit will not be expired.
Correct. Defendant number 1 is the husband of whom? Defendant number 3.
She claims not, but she is.
Correct. Who is your husband?
Defendant
Defendant number 1. So you're the daughter of defendant number 1. Fine.
Number 2 is daughter of. Plaintiff is son of defendant number 2. Defendant number 2 is daughter of. Defendant number 3 claims that she is the second wife of defendant number 1.
And dependent number 2 is the daughter of dependent number 1 and dependent number 3. Then you're the child of first wife, Then who is dependent number 3? According to her, she is the wife of dependent number 1. And what property is this? Ancestral, joint family, or it is a then she is entitled for share, right?
Husband is they have produced death certificate. In fact, in that evidence and method or rate the name of argument mirror, she has filed death certificate or not. The address
Not the death certificate
of first husband of the husband to maintain this date. Other of plaintiff was expired on 22/1/2009. On 18/2/2009.
Anyway, it is listed on 21st, Alva. Come back. Steps to be taken in respect of respondent number 1 and 2 by a week. Paper publication to see FDP nalli. This is the very counsel who has appeared before the final decree court. Then you take steps by a week. Immediately after service of notice. Bharata. Nothing will happen in FDP. ಏನು ಆಗಲ್ಲ. Yes, you need to comply.
Being for petitioner, my lords, a week's time may be given to comply office objection. My lords.
Whose submission has to be noted? Petitioner counsel seeks them to the officer. With this for week's time is.
Babu?
Who's the memo? Petitioner, then counsel for the petitioner seeks to withdraw the petition and files the memo. Memo for withdrawal. To be signed by the petitioners. Memo reads as under. In view of the memo file, the petition is dismissed as withdrawn.
Karen?
Ah.
Election B and C are not being relied upon and relied really on election A, which is the impugned order. They have disconnected my power supply. I have been paying this suddenly bills concerned have been prompt and paid. Suddenly one woman claims that I'm not the owner of the property.
Who is in possession?
I'm in possession. We are in possession tenanted premises which have been restored and we are getting rent.
Any landlord tenant is.
Because there is a clear document.
Have you made the landlord as a party to the proceedings here?
I'm the owner of the property.
You are the owner.
Yes, the grant was in my name. Grant had happened in my name. So I built some commercial premises there and restored the property. In 2018, they have granted an electricity meter to me and I've been paying rents on the bills also very promptly. Election H series is the proof of my payment. I'm a 100-year-old woman. Deriving rentally from this particular commercial premises. Shops have been there from 2018 onwards. One fine day, one woman comes and claims that I'm not the owner of the property and the connection has to be disconnected.
So at the behest of this Mohan, the connection disconnection
has been disconnected. In RFA is also pending. They had issued a notice in February 2024. I have responded along with documents too. Subsequently, one more notice. Each time they have given the notice, I have responded to those notices also. But in spite of it, they have taken up they have stepped into the civil court.
And the order now which you have impugned here?
The impugned order is annexure A at page 20. They say that they have taken they say that Sthavar Akramavadi Vidyut Samparka Padegirudagi Guru Nimittu. Now, if that had been the case, they could not have granted it to me initially in 2018 itself. 2018, they grant the thing, even when I have to apply, I have produced documents. It's not that they, just because I give a blank application or a signed application, they come and they grant or install a meter.
Yes, H.V. Devaraja is directed to accept notice for examining number 1. Learned counsel, the learned counsel for the petitioner. The counsel for the petitioner submits that the petitioner is the owner of the scheduled premises, having re-granted to him and 7 others by the order passed by the assistant commissioner. The petitioner was sanctioned with the power supply in the year 2018. Pursuant to which the petitioner has let out the scheduled premises to several tenants. It is submitted by the learned counsel for the petitioner that at the behest of one Mohan, the responding number 2 has issued the impugned notice, directing
disconnected also.
And the electricity supply has been disconnected despite there being no default in paying the electricity connections till date. The circumstances made out. The respondents are directed to restore the electricity power supply forthwith. Yes. Pending consideration of the petition. Thank you. Hand delivery to be hand delivery ordered. Now that we have restored this connection, and also further not to take any coercive steps pursuant to annexure gain. Mr. Rambhat.
Suspended.
What is-
Third round of litigation. Without there is any reason, the district magistrate has suspended the ceremony.
Just a moment. What was there before the trial court? What was pending before the trial court? Application. What
Cinema
was,
also came before the Honorable and the Public Districts in earlier application. No partitions is valid.
what is the order and the challenge now?
The license in the name of three sisters. One sister is questioned. Christina is questioned. Election years into law, my lord. Page number 21 may be made. Authorization. There's no reason, nothing. Why does that happen? We two sisters are there.
When was, till when there was
For
license?
1 year.
Cinema license was granted to you for 1 year.
Why?
From when to when?
That is at page number 20, page number 24, up to 61-24 to 61-25. Okay, 5 years, not only for 1 year.
What is a family dispute?
It is in there, yeah. Property. It's not a matter.
So according to them, this license was for the family, na?
Three sisters. You have to make any see the name of the license holders. At the top. Krishnamma, Lataju, Madhu, and Satyajit. Sisters. Three sisters, and one sister is no more, and there's some son.
Now both the sisters are fighting.
Two sisters on one side, and one single sister on the other side. Majority is to run the cinema.
There was any partition suit pending? Partition suit pending?
And there is one eviction suit in regard of this property is pending, filed by them. And earlier their matter reached up to the arbitration, Justice Keshav and Raman arbitrator, that was not pended by the party.
License was earlier to the family of the petitioner.
3 members together.
Now this license which is there in your individual capacity.
Now, individual. There's some observing electrified payment of course they have done for the payment of some copy. Limited resource single. That is
In whose license, in whose name the license was granted first now?
First of all, there are from there are three sisters. Shinama, Kandama, and Satyajit. In this form, the partners who have been allotted the license from for many years. Now, what is happening is this particular petition number 1, Satyajit. Her son is respondent number 4. Here. Now, what the petitioner has suppressed because multiple voted as per mentioned, we should be that the entire form has been resolved as per letter dated 23rd March 2024. When you go back to that letter, they don't even see that. So I can them just produce this document separation money there.
it's not in the party. It is a late.
There is a separation. 87-year-old. She has
No, you just tell the fact. Let us see.
On 23rd March 2024, I have issued a letter to your partners. As on 23rd March 2024, only Satyajit was there. Kablama passed away. After she passed away, only 2 partners are
So
there.
reconstitution has taken.
No reconstitution happened.
Oh.
The partnership had built. So I gave a notice. But the problem not to be other legal taking that one, anyways, the form was fraudulently carried out. He didn't have the one who has it legally. That ultimately, keeping the earlier litigation right, I have a new also, 2 partners, 1 right, 3 partners, 1 right. The partnership matter is not resolving. Now, after this letter, I also write to registrar of form saying that the partnership is dissolved. Then I also write a letter to respondent number 2 stating this form is resolved and also stating this preferably amount of the petition by 1 has obtained a license in the year 2020 in the name of some number who is also dead as of that date. So I write to the second respondent saying how have you issued the license in a dead person's name and in any event this is to bring the notice that the form is dissolved. No license can be given without my consent in any event nothing will be done. This is very, very much petition. This is 20th July 2024. I write another letter to the second respondent saying that I dissolved the form. But when I go to the theatre, we usually count the leave amount cash and the tickets for that. So I write another letter to the second respondent saying I have dissolved the form. I informed the earlier license was expiring in the month of June. Much before the expiration, I have raised my protest. So I bring the notice to the second respondent saying how can the license, how is the theatre running without any license? Please seize the theatre. Now, when I gave the resolution notice, this petitioner replied, in my resolution notice, I asked for admission of accounts and all books of accounts. The second thing I replied saying I'm not making anything. So then I bring a notice, all of this to the second respondent's notice. This is on 20th July. Then once again, I get one more representation.
So from 20th July down, from 23rd March 2024 down to date, who is running the cinema?
The option believe as of now it is it is a fourth respondent. Here, partners are not part, the other partners, assuming the partnership form because they are not running it. In fact, if the lordship will see
No, then the grievance should have been of Kiran, right?
yes, the lordship.
Where is Kiran here?
Responding for the whole thing, one of my first
Who are you? You are the partners of the firm. Why are you objecting for the petitioner? It should be by the Kiran, right?
the letter itself is not maintainable.
No, Kiran is a party here. Kiran is a party.
And anything form is resolved. The lordship one was submission.
This is an internal dispute between the partners of the firm, right? Now,
Form is resolved.
correct. Form is dissolved, you don't want her to continue, that is one thing. Now, if at all he or she is continuing this business of cinema up to today, it is for the Kiran to raise objection. Why are you raising objection? Why?
Because he is having the
No, God, this is Premalata. Who is she? Satya Prema.
Release sought the legal है, license country to my permission legal है. Then admittedly it's not them who is running the firm.
Satya Prema and Kiran, are they together? No.
No, Kiran is a mother.
Then you mean.
Yeah, there is no partnership of license, it should be proprietorship. Partnership is not a control and
No
it's
submission. The issue of the part. So I tried to second respondent saying that the form is dissolved and earlier license was given in the dead person's name. Surely the second respondent is not applying any medical system. Now what happens is all of a sudden, after I submit my representation, all representation are there. 11 September, someone mail letter. Our letter, the second respondent says that reference your application for renewal of license to June 2024 and then based on that, alleged license is given. So immediately I am sure I have not given any letter. How come the license has been renewed at my instance? So I write a response to the second respondent, which is a letter of reference in the reference letter 5/6/2024 on the basis of which you have given the license.
When was this license granted?
Allegedly on 15 July 2024. So,
15 July
2024. So, I give a response to the second respondent saying, I have not given any application. Whichever application of time, give me a copy. So that immediately the second respondent was well aware that license could not have been given. Some of these people have obtained the license. Then what they write is, I file an RTA application, get that alleged letter. Please see the conduct of the petitioner, then an application has a petitioner. Then the signature force ಮಾಡಿದ She is 87 years old.
All are sisters, right?
Is it-
Is it not? You all are sisters, right?
Obtaining fraud money, if they want to speak,
Yes.
they welcome this matter, but they expect for mediation. I have serious objection, respectfully, your lordship. Fraud can be a, may just submit judgments, your lordship.
No, we are not hearing you now. We are hearing on the petitions which has been filed by them. Now they are against the revoking of the cinema license.
Alternative appeal is there.
Where is that other alternative?
Section 17.
Seventeen is there, but it's
Your lordship, I have seriously disputed.
Other.
There's no reason as a, if there is reason as a, I would have gone to appeal. Because he has seen any reason.
ಎಲ್ಲ reasons
ಯಾವ reason ಇಲ್ಲ. 17 ಅಂದಿದೆ, appeal ಇದೆ. If there is no reason assigned, if there is no fact considered, while appeal is known,
all these contentions can be heard. Show cause notice should have been given. It is admittedly being given to these petitioners.
Yes, where is that provisions?
17 payment.
Ah. Ah.
If the license authority satisfies that the holder of the license is without using the law, may progress the petition to which license is granted or has contrary against provision of the
Where is the show cause notice issued to him? Show cause notice to the petitioner.
case number 64, section A, section G. Total notice to move the survey, within 3 days. Morning we submitted to the, our representation. Afternoon we received the call.
The lordship, and what is pertinent to note is, all these rulings are already considered. If the lordship will see
So they were in a hurry to consider that.
the lordship.
11/9 they issue a show cause notice. When was it served on them? When was it served on them?
And it's on 14th Friday, that's all. Saturday, Sunday holiday.
Not the case.
Monday is submitted. Monday evening is you.
Their reasons is not that they didn't get an opportunity to being done. That is not required also. Section 17 required, 1 day required us.
So without hearing, you can pass any order. That is what it says. Yes.
Lordship may also submit that this is the legal judgment, directly on account of the practice.
Yes.
And the period to your lord, there is this prejudice which is caused, and the absence of the lord, accountable to the suppression by right.
You file all your objections.
The lordship for
You will say the impugned
Your lordship,
revocation.
may I just, honestly, your lordship, seriously a case where I have taken so much of only objection, there is just one document. The lordship, just more it apart during the mediation meeting. My respect for the commission, I would not have made so many submissions if there is no genuine, at least with my judgments to your.
For an interim order, you want to place judgment.
The reason that I'm submitting this thing. Even this was not a genuine, or if there was any fault from my end, I would have definitely bowed down to whatever that is. But the fraud, I think they have taken the, and I find it foolish.
When sisters can fight, there is nobody on the earth who cannot fight.
She the elder sister.
Correct. You are a younger sister. You are an younger sister.
Elder sister.
You are an younger sister.
Elder sister.
So then elder sister should be more coming forward for such settlement.
Your lordship's fraud not there.
Correct.
Your lordship kept its place and just this will.
If this is your way of submission, madam, then
Your lordship may I just.
not very appreciable. Yes. What is that you want to do?
Your lordship, if at all they want to mediate the money, like what will be given to them to do the mediation board, I will file my objection. In the meantime, for today, pass to the lordship. Let it come to mediation. We'll see how it can be settled.
Pass over. ಅಷ್ಟರಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
Again, my lord, section D is completed.
Please don't refer all this. She's always your sister.
Equally applicable for.
You're an elder sister, as you rightly said, you're an elder sister. Elder sister is like a mother. You know that? You know that?
Let them come to section.
It's muddy.
Mediation.
Mr. Rambert avre password. 230. What is this order? Who are you? Grantees. You are the grantees, Alva.
Yes.
And when was the sale?
That's the same was. That is 10/1/1963, madam. The dispute between management two.
10/1/1963. After the coming into force of the Abolition Act.
Yes.
Alva.
Yes.
Then 1978 Act Olagade Bandre, they are saved.
Yes.
Then what, when did you challenge this order?
We have the department number that 12 to 20 before the first of platform.
You are the grantees, right?
No, madam, we are the agreement holder. We are in position of
Agreement holder,
Yes.
not the purchaser.
Not-
Then agreement holder has no role here.
But the respondents also. It's the real dispute between the two, the in-on service, the office holder.
What is the right of an agreement holder? What is the right of an agreement holder? Will they confirm any right in your favor? Will agreement of sale confirm any right in your favor? Then
Yeah.
we can understand if there is a sale deed. Sale deed protects you in light of Lakshman Gowda's and Bashir Ahmad's case. But not an agreement. Is it not?
Facts. It's facts of the case. 99, madam.
You want any orders on this petition?
And we have approached the Supreme Court, that the interim order.
Then,
Disposes.
comply the office objections. Petitioner counsel to rectify the office objections within a week. Is this matter immediately after Dasara vacation?
Next month is very same, another appeal.
Same. Yes.
Location.
Yes, Mr. Lokesh. Next step. What is the interim order now you're seeking? Who is operating the service now?
I'm always,
Huh?
I'm operating service, even of the subsequent renewal period, that is connection C.
You are operating.
Yes. Because
You had any benefit of interim order before the in RP?
yes, this reason, because the tribunal has
Sit down, yeah.
previous renewal. It is renewal has been satisfied.
So let him take notice. SCGP to accept notice for respondent number 1. Yaru? Harish Bhandari to accept notice for respondent number 2. Akshay Merchant notice to respondent number 3. Is this matter after ensuing Dasara vacation?
Party has kept in action there, 158. Similar one.
So that stay ಕೊಡ್ತೀವಿ.
I-
ಕೊಡಿ ಅದನ್ನ.
Because they have already heard the matter, and they have given.
Petitioner to serve the writ petition papers on the learned Learned counsel for the petitioner submits that the impugned order passed by the appellant tribunal in RP number.
But there is a typographical error in one RP number. Actually, it is 22/2023. It is mentioned 22/2023.
ನಿಮ್ದು ಏನ್ ಹೇಳಿ 122 ಅಂದ್ರೆ 23
ಅದು 23 correct actually. ಅದು annexed ಮಾಡಿದ್ದು. Order sheet is also annexed on F3.
148 of 2022 and
Correct.
RP
Another number 23 is wrong. 23 is here.
correct ಮಾಡಿ 23 of 2023 correct ah? 22 of 2023 na 23 of 2020
It's correct. Order sheet of the same as next.
ಅದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್
I have served the copy on the wrong again. Still I have served the copy on the R3 on 117.
what is the office objections
Caveat.
you have not
One
served
caveat is
anta
that I served.
who is the caveator
Okay, I served. That is R3 only.
ಅದು ಹೇಳ್ಬೇಕಲ್ಲ ಎಂ ಇ ನಾಗೇಶ್ ಫಾರ್ R3 ನಾ
I served
ಅದನ್ನ
on
ಕ್ಯಾನ್ಸಲ್
27
ಮಾಡಿ
last night.
SCGP to accept notice for respondent number 1, Harish Bhandari for respondent number 2. Learned counsel for the petitioner submits that the caveat that the petition papers have been served on the caveat M.E. Nagesh. With ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅಲ್ವಾ
Those are.
registry
But he has not signed on the original court copy. I will say that.
M.E. Nagesh. ಅದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇರೋದು ತೋರಿಸಿ ಔಟ್ ಆಫೀಸ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರನ್ನ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಈಗಿದ್ಯಾ then if petitioner counsel
7th I served on.
ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅವ್ರಿಗೆ petitioner counsel submits that he has served the petition papers on the caveat M.E. Nagesh registry to show the name of M.E. Nagesh as a caveator for respondent number 3. Office to verify and proceed. Amele learned counsel for the petitioner submits that the impugned order passed by the appellate tribunal in review petition RP number 148 of 2022 and RP 22 of 2023 are placed before the respondent number 1, Regional Transport Authority, in a meeting scheduled on 18/9.
Time for return submission. Decision is not pronounced.
Has been kept in the meeting and date. In light of the same, the respondent number 1, Transport Authority, to hear the parties, however, defer passing any order pending consideration of the same.
Here also.
Connect this petition along with 24058 of 2020.
Kumar dear.
What is the representation you are giving? In public, is it not a public interest litigation? Is it placed before your place? Then public road nalli public grievance. This is all in the guise of public interest litigation. You are coming before this court. Alva. Then how is the petition maintainable? ಸುಮ್ನೆ ಒಂದು representation ಕೊಡೋದು consider ಮಾಡ. What is the representation? This is not the grievance of an individual petitioner. ಅಲ್ಲ ಇದು not the grievance of an individual petitioner. ನೀವು ರೋಡ್ ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ ನಾನು ಬಂದು ಹಿಂಗೆಲ್ಲ ಮಾಡೋದಂತ go and file a PIL. Not no Mr. Kasu. We will not still you want to press this, we will reject your petition. What you want to do tell us. ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ? No, we are not. No, we were not going to give any. You know ಅಲ್ವಾ ನಿಮ್ಗೆ ಗುರ್ತಿದ್ ಮಾಡಿದ್ರೆ ನಾವ್ ಏನ್ ಮಾಡ್ಲಿ ಮಲ್ಗಿದ್ದವ್ರನ್ನ ನಮ್ ಎಬ್ಬಿಸ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಆಗತ್ತಾ
Then I will take a appropriate step to.
You withdraw this petition, file appropriate PIL ಹಾಕಿ ಜೋರಾಗಿ ಹಾಕ್ಲಿ No, mister, we are not going to consider. Mr. Consul, we are not, this petition is not maintainable. How is it maintainable? It's a public grievance. You are asking us to exercise 226 in this. What is your right violated now? What is your personal right? Then go and file a this PIL. Is what you propose to do, tell us. Then Martira. You want dismissal? You want what you want? Dismissal, alva? But yen heli? Comply by week. Comply by week. Yes.
Serial number 20. EB.
Correct. ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? Will dismiss for non-prosecution. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? We have been waiting. They don't come, what to do? ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ನೀವೇ ಹೇಳಿ? There's no representation even today. This matter after ensuing the vacation immediately in the week commencing from 28th. We cannot ask them post ಮಾಡ್ಲಿಕ್ಕೆ ಬರತ್ತ. They should come out. What is the settlement? What is the direction you have thought? Yes, what happened? Pension antana, what is that you want? What is the case of the petitioner? He was temporary appointment, huh? Refusal on prakara.
Thereafter, after 6 months, now in factory itself is transferred to this. ಅವಾಗ ಇವರು ಹೋಗಿಲ್ಲ ಅದನ್ನ ಕೊಡು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ಆ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಎಲ್ಲೋ
Now he is working somewhere. He is working somewhere. ಬೇರೆ ಕಡೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. He is not joined this. From what period to what period you are entitled? When did you join the services?
Wages, that gratuity from the date of appointment till the date.
No, they are not resigned, they are not. There is a charter of demands case, there is a transfer also, they have charges.
The appointment is from 2014 to 2016. They are claiming wages, alva? Wages. From 2011. 2001. 2001 to 2011 you are entitled.
After 14.
14 ಯಾಕೆ?
ಅವರು ಅಲ್ಲಿ ಒಂದು ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ ಜಾಯಿನ್ ಆಗಿದ್ದಾರೆ.
ಅಲ್ಲ, according to you, refusal is on.
Asking them to go for duty.
From
14.
14. So you are working from 2014. Yeah, you are not working, no?
Pending is like labor protest, they have filed a memo. They are ready to accept them and come and join them. Thereafter, they have joined and they have worked for us about more than 6 months. Thereafter, they have been shifted to Tumkur.
They are challenging the transfer order which is pending before the labor.
I mean,
Like all 17 workers are working already there in Tumkur.
ಎಲ್ಲ matters ನನಗೆ ಇಲ್ಲ ಮಾಡ್ತೀನಿ. Let me pay the statutory fee.
The statutory dues from when? 2001 to 2011.
Fine, with the date of the-
Even otherwise, they would be entitled to that. Okay?
Sign ಮಾಡಬೇಕು. ಅವ್ರು
ಇಲ್ಲ,
ಯಾಕಂದ್ರೆ
ಹೌದು.
ಕೆಲ್ಸಕ್ಕೆ ಹೋಗೋದಿಲ್ಲ ಅಂತ. ಕೆಲ್ಸ ಬೇಕು.
See, they don't want to work after 2014. They are not entitled for any benefits. See, even otherwise, they are entitled for that or gratuity. What is it? Hmm. Hmm. Hmm.
There's so much in legal, we are ready to give. We understand it, but they also need to understand that. They are very.
See, now that they do not want to work with your institution, okay, establishment. No, but then from 2011, there is a refusal according to them. There is a refusal of work 2011, where however, in the year 2014, you said you please come back and we will take you into service. That's all, right? That's the correct. Now, they would be entitled to certain gratuity during that period, right? 2001 to 2011, assuming or 2014. 14, they would be entitled for all the statutory benefits what they are entitled to. That is their right which they have to be. So why don't you pay that amount? They will withdraw all the petitions which they have been filed against the several forums. So they will say that they are refusing, they do not want to join your establishment, but please clear all the dues, what is, yes, how much time? So they are ready to pay that amount, let them pay that amount, that will be given some time. Ah. Hmm. So your continuation is just to take time for them to take time for you to pay the dues which they are entitled. Yes, Mr. So, Mr. They are accepting for 6 months. We pay the dues within 6 months. File an affidavit to that effect. Will close when they will withdraw all the petition. So pass over. Just come back. After. Come back with what are the terms they are saying. Yes. Yes. Pass over. You just let them know. Yes. Pass over. Yes. Yes. Why is this listed for admission? Why is it listed for admission today? Pass over. I think for settlement, right? Something was there. What happened before the mediation? No, the other day he made a mention, this is covered by Vinita Sharma.
So an unnecessary party, but that has been acted upon and defeated.
Correct, they have set aside the order, 1/7 share. Who appears for the plaintiff? Dependents, other dependents. You appear for which dependent? Who is third dependent? He is the contesting respondent. Then. Hmm. Pass it.
Number 1, dear Sanjeev.
Yes. Why is it restricted? You did not settle. So what you want to do? This matter after Dasra vacation 2020.
Nirmala?
Yes, madam. Petitioner to comply the office objections within a week. Yes.
Hearing on aye. Till number 3, Sanjeev BL.
No representation for the petitioner. List this matter after 2 weeks. Correct.
Final hearing. Till number 4, dear Sanjeev. Yes, 9. 52. Till number 4, dear Sanjeev.
On this matter, no representation on either side. List this matter after Dasra vacation.
Till number 5. NC Basaraju.
Yes, Mr. Baswaraju. List this matter after the no representation.
6. NC Balraj.
No representation.
7. Sanjeev BL.
Yes, Mr. Shekhar.
Shekhar for responding.
Representation on either side.
Number 8, Harish Bandariti. Shekhar.
Reconciliation report person. 5 minutes. Conflict first question. Yes, what is that? No.
This matter, nothing is another without mediation, because mediation is for in this matter. Solve mediation. In the matter, say, for time being, because if it is wrong, it's not possible to get it.
It will not be granted, otherwise they are the litigation is so no, they will again take.
When the parties are mediating.
That's not why what
But either of it will not happen. See, reason is we will refer the matter to the mediation. There won't be stay, you will not insist for mediation. If there is a stay, they will not insist for. So this court has to take some order, pass some order, which would be benefiting to both of them. So by then, what happens to the business? See, you are.
They are not maintaining this account. They are not doing anything about the license. Respondent number 4 allegedly is where years of part 150.
We will see. Yeah, this will take some time, so we will see afterwards. You carry him the courage. We'll hear your matter at 2:30. 2:30.
Number 23, this one for dictation, government certificate.
Heard, reserved. This will take some time. Reserved.
Number 24, Rohit.
Reserved.
25, Mujita Peshwa.
Reserved. Yes. Request on both sides. Please this matter after the clarification.
27, Mohan Kumarti.
What happened? Father, son, daughter, huh? We'll refer to mediation. Bartar, see, they are all, yes, looking into the nature of dispute and the relationship between the parties. Parties are directed to appear before the Bangalore Mediation Center, Karnataka Mediation Center, Bangalore, on 15th at 2:30.
28, Gautam Sadula.
Mr. Gautam? Yes, yes, of course. So she's been giving a relieving letter, right? That's all. Correct. Good efforts on your part, madam. Joint memo is filed by the petitioner and the representative of the respondent will be signed by their respective parties. The terms of the joint memo reads as under 1, 2, 3, 4, 5. In terms of the joint memo, the writ petition stands disposed of, and the award dated 20th July 2024, passed in reference number 5 of 2016, is modified in terms of the joint memo. Yes. The petitioner acknowledges the receipt of the demand draft as well as the relieving letter in terms of the joint memo. Accordingly, the petition stands disposed. Yes. The appreciation of both the counsel are placed on is placed on record.
Further hearing,
The efforts made by both the counsel are appreciated. Yes. That's it, not really. Petitioner, no, accommodating. Yes, next.
number 29, Sharat S. Gowda.
Just a further hearing. Read court notice. Read court notice.
Mr. Krishna.
Mr. Krishna. In her. Judge.
The call has not come back to the original idea.
Judge, huh?
Actually,
Fair and proper, huh? Yeah, either. Inquiry is held fair and proper. What was this again? Termination, huh? He was on temporary basis. What does the appointment order say? Then
That it was continued, extended continuously for over 9 years. So it's a fact that he has worked continuously for over 9 years. Once a workman has worked continuously for 9 months, he has to follow the original idea. And when you look into the observation by the court.
Page number. Yes.
All number 1 to 3 on its basis, so they are not referred for adjudication. Even otherwise, it doesn't repeat. Second party is not disputing that the first party is vulnerable, and second party falls under the definition of interest. The disputed person falls within the definition of the dispute. So all these three factors are acquitted facts. Once these three facts are acquitted facts, they are out to follow the provision of interest. But whereas the labor code has not got the provision of this fact because of the termination. It's also an undisputed fact, both in the counter statement as well as evidence.
When were you discontinued from service?
From 3/1/2003.
And when did you raise a dispute? 6.
In between.
Anna, you kept quiet for nearly 4 years.
Yes, sir. I'm not disputing. I have made many more representations. Every time I cannot go only before consideration. I would like to find a lot of others within I can continue. Since all my efforts failed, I am also in representation.
When did you give your representation?
All of them, my own representation plan and some other representation file. I have given a representation in 21/4/2007, which is connection.
Right. You kept quiet for nearly 4 years. See, if you really wanted your services to be continued, you would have made efforts immediately. Only that. When you go to an establishment, you have been refused work. Will you not go to that establishment and seek for your grievances? You kept quiet. You did not want to go. That's what it shows. Ah. Where is that material to show that?
It was failure. I paid the consultation.
See, they don't know. Petitioners, when they get a job, it's a God's gift to them. They should take it very happily and they should do that work with the utmost care. And okay, when they are not done or they for some reasons there's some misconduct on their part, they have been not taken into services. You should make an effort to go back and join. If you don't make an effort, how can an employer assume that you will be coming back and you will be reporting to do work?
Yes, yes, yes. Otherwise, work nature or physical is not followed. There was no back and forth. There was no Ramesh answer is in my name is.
Where is the appointment letter? You'll go only by appointment.
Yes. I see one.
Post is for temporary post,
Temporary post is dated
1994.
and duration of appointment this is an expensive.
And where is the continuation of your letter?
Fifteen 1994, I have been received. And the various others that all the others. Last page was diploma mechanical working so from 15 1992 days. And they were all attributed to this fact that they have been nice service of extended from time to time. That thing is. Then it could be their own property. Page number 37. Page 37. Page 37. The first one, she can here Nagaraj was appointed in the month of March 1994 as temporary right? Then I got the bank for a period of 6 years. They are asked to withdraw the requirement by extension from time to time by TEB. But factor in the meantime, TEB called for application on 2011 from the eligible person for putting up of the course of station attendant or grade. The first part house fund is issued. And first application for the first part was rejected on various grounds, including that he was overaged at the relevant point of time. However, temporary employment of the party was extended from time to time in TEB. So again, Adjournment was engaged in DB plan and better with this. But then TEB, now TEB and services extended from time to time. Repeated in the outside launch, they are expected to that.
Yes.
When you get to page 5, sorry, page 37, paragraph number 5, page 96. The temporary employment of first part was extended from time to time. The task extension of temporary employment of first part. The reading and help for up to 3. Thereafter, temporary employment of first part was discontinued as a normal. At the first of the employment where the second part. One was as an authorized job. This two by the first part. So when I have been extended, I have continued to work for more than 240 continuously. Provision of industry dispute has to.
Yes.
Apparently, they are not followed any of the provision of the idea.
Your petition has to go on the ground of delay on the list. It is a stale dispute.
There's also Limitation Act and.
No, not limit, it is not a limitation.
Or it is something greater than something different.
No, this is stale, right? From 2000,
They have evidence, they produce documents, so still they have never aroused the problem. They have not been taken this is stale. They don't have any documents, they have produced the documents, they have produced evidence. The person still never aroused the problem. The only said it's a delay as action, not a question of stale or its status. And this particular aspect has been relied upon by various mediations. What it does, relied upon current sector also producer.
one ಯಾವ್ದ್ರ ಕೊಡಿ ಅದರಲ್ಲಿ, which is important according to you. Correct. Which is that? Even the prayer they are seeking in for the labor court. What is the prayer for regularization? What you are seeking for?
My interpretation information first.
Where was the termination at election? Termination of this no. Because it's a temporary. Is a temporary.
My lords, I am appearing for respond number 1, my lords.
Oh, yes.
My lords, the petitioner was appointed in the year 1994 March, my lord, for the KEB, my lord. KEB for a temporary gang member as a temporary gang member for the KEB, my lords. In the year 1998, he has attended for the attender post in the year 1998 called by the KEB, my lord. By that time, his application was rejected. That reason that he is age barred, my lord. He has not challenged that rejection order, my lord. In the year 1999, my lord, KEB divided in 2 parts, my lord, KPTCL and VVNL, my lord. After dividation, my lord, he has continued as a temporary employee in the VVNL, my lord, up to 2003, my lord, 3/1/2003, my lord. On 3/1/2003, he has been terminated by the VVNL, my lord. Later on, VVNL, Vishweshwaraya
Respondent
Vishweshwaraya.
number 1.
Yes, my lord.
Who is respondent number 1?
My lord, I am appearing for respondent number 1, my lord.
Correct. Who is he?
My lord, KPCL, my lord.
KPCL.
Yes, my lord.
And who had appointed the petitioner?
KEB, my lord.
KEB. KEB is not a party yet.
No, my lord. KEB divided as a KPTCL and VVNL, my lord.
When was it?
1990, in the year 1999, my lord.
So from 1999, this KPCL has taken the charge of.
No, my lord. In the 1999, KEB divided in 2 parts, my lord. KPTCL and VVNL, my lord. VVNL was continued up to 2006, my lord. On 2006, the VVNL merged with KPCL, my lord. On 2006, my lord. By that time, this petitioner was not on the roll of KPCL, my lord. He was terminated in the 2003 itself, my lord, by the VVNL.
So,
and he made a reference application to the labor inspector, my lord, in the year 2008, my lord, after lapse of 4.5 years, my lord. On the said reason, my lord, kindly turn to page number 114, my lord.
Application was made to whom, Mr. Consul?
Reference application made to the industrial. My lord.
You said after his termination, the
Yes,
year 2003, to whom did he make an application?
He moved an application to the labor inspector, I think, my lord. I'll go through it, my lord. And later on, it was referred to the industrial labor court, my lord. Labor court, my lord. In the labor court, page number 114, my lord. Based on the by giving the reason that he has moved an application after lapse of 5 years, my lord, and delay. And one more contention, my lord. He had applied for the station attendant in the year 1998 for the KEB. His application was rejected. He has not challenged that order. In page number 114, my lord, REF 13/2008.
Yes.
Ali para number 18, my lord. Though his application for the post attendant grade 2 given during 1998 is not considered on the ground that age bar. Firstly, first party has not chosen to challenge the same on the ground that he has already into service. Thereafter, he is continued up to 2/31/2003 on contract basis, and after his contract was extended, first party has not chosen to challenge the same under the circumstances, both on the ground of merits, on the ground of limitation. First party is not entitled for any relief. Now coming to the question of delay, admittedly last contract entered between the first party and second party has came to an end on 3/1/2003. The present reference is made in the year 2008. There is a delay of 5 years raising the dispute. First party has not given any reason for the delay. The very fact that there is the inordinate unexplained delay is raising the dispute goes to show that in fact there exists no dispute. In this regard, the following decision of the Honorable Supreme Court are relevant anta ಮಾಡಿ ಈ ground ಮೇಲೆ dismiss ಮಾಡಿದ್ದಾರೆ, my lord.
Yes.
And he has not served continuously for 10 years, my lord.
From 2019?
1994 March to 2008, my lord.
2008, 98.
1999 to 2003, my lord. 3/1/2003. He has been terminated by VVNL on 3/1/2003, my lord.
3/1/2003.
My lord. VVNL, by the VVNL, my lord. And VVNL merged with the KPCL on 29/12/2006, my lord. On that day, the petitioner was not on the roll of KPCL, my lord. He was already terminated by the VVNL in the 2003 itself, my lord.
That's all. One more. I will refer those judgments. Yes.
Whatever they rely upon it also. 13 years, 12 years, whatever they are. And not a single word is mentioned watching. They avoid afford provision very at the top. And even though we have admitted the fact that this is
Workman, Petitioner Workman is before this court assailing the legality and correctness of the award dated 31/10/2011 in reference number 13 of 2008 on the file of the Additional Labor Code Bangalore, wherein referred to as Labor Code for short, whereby by the implement order, the Labor Code rejected the dispute raised by the workman. Next one. Brief facts are that the petitioner was appointed by the KEB as a junior engineer as per the order dated.
Not my lord, temporary gang member, my lord.
Junior engineer alva?
Allah, my lord, a temporary gang member, my lord.
Where is that appointment order? Junior engineer anta ideyalla, Mr. Conson. Name of the post is what? Mr. Conson.
My lords. Sorry, my lord. Just a minute.
Junior engineer.
Petitioner was appointed by the KEB as junior engineer as per the order dated
11/3/1994. on temporary post. Inverted comma, sorry, for temporary post. For carrying out operation and maintenance works in the 120 MW. 120 M.W diesel engineer power plant at Yelhanka. Petitioner workman raised dispute for adjudication under section 10(1)(c). This dispute. The appropriate government by its order dated 18/3/2008 referred the matter for adjudication under section 10(1)(c) of the Industrial Dispute Act, IDL for short. Raising the following points for reference. Page number 100. The petitioner filed claim statement containing one, that though the order of appointment is for on temporary basis for a period of 6 months, the further order of appointment issued is for continuous service, and the services of the workman has been utilized up to 31/1/2003, and he has continuously worked for 10 years. And every year he has put in 240 days of service. That other candidates who were appointed along with the workman has been absorbed in regular basis. And though the first party made several representations, several representations were made, his request was not considered, and there is clear victimization and unfair labor practice. And neither he has been paid any compensation as provided under section 25F of on notice, the management of the corporation appeared and filed their counter. Inter-alia contending that the workman has raised this dispute, alleging refusal of work with effect from 3/1/2003. And the dispute raised is after the lapse of 4.5 years. And no reasons are forthcoming for the delay. That the appointment of the workman on the year 1994 was on temporary basis. Initially for a 6 months, and which was extended from time to time. Next, ABC. That the KB had called for application on 20/11/1998 for eligible persons for filling up the post of station attendant grade 2. And his application came to be rejected on various grounds, including that he was over age at the relevant time. That the KB was bifurcated into corporation during the year 1999, namely as Karnataka Power Transmission Corporation, KPTCL, and Vishweshwaraya Vidyut Nigam Limited, VVNL. And the second party number 1, KPTCL, and the KPTCL, second party, and the KPTCL comes under the administrative jurisdiction of VVNL.
Not my lord, KPCL, my lord. BVNL came in the administration of KPCL, my lord, in the year 1996, my lord.
And now in this objections, you have stated that it is KPTCL comes in the
No.
administration.
VVNL merged with the KPCL, my lord.
Come to page number 109. Your objections are contrary to your own statement of objections there.
KPCL, my lord, D, my lord. VVNL was amalgamated with the Karnataka Power Corporation Limited.
Earlier paragraph.
19 KB was bifurcated in two corporations, Karnataka Power Corporation, KPTCL, Vishwashraya Vidyut Limited. The second party number one, KPTCL, came into administration of jurisdiction of VVNL. Yes, my lord.
Then
Yes, sorry, my lords. I apologize, my lord.
BVNL. And the temporary employment of the workman was extended from time to time by VVNL. And the last extension of the temporary employment of VVNL was up to V1 2003. And this employment of temporary appointment was discontinued as there was no work. That VVNL amalgamated with Karnataka Power Corporation KPCL on 29/12/2006, as on the date of the refusal of work as contended by the workman. The workman was not on the rolls of Karnataka Power Corporation. Before the labor court, the labor court framed additional issue which reads as WW1 examined, the workman examined himself as WW1 and marked documents at exhibit W1 to W28. On the other hand, the corporation examined the concerned officer as MW1 and marked documents at exhibit N1. The labor court, by the impugned order, rejected the dispute on the ground of delay as well as on merits. Both the learned counsel appearing for the petitioner and the learned counsel appearing for the petitioner. The learned counsel for the petitioner vehemently contends that, as under one, that the management has deliberately indulged in unhealthy labor practice by employing the workmen under the so-called tenure of temporary service and then terminating them for a day, even though such jobs are continuously available. That the said aspect was not considered by the labor court and has erroneously dismissed the petition and dismissed the dispute raised by the verdict. That the labor court ought to have noticed that after the illegal termination of the service of the petitioner, the petitioner had made several representations and they were not considered. The non-consideration of the representation, the petitioner had raised the industrial dispute. To submit that rejection of the reference on the ground of delay is a clear case of jurisdictional error, and hence the award needs to be set aside. That the petitioner nearly served for a decade in the respondent establishment, and having been recruited in the year 1994, and after serving for about 10 years without a break in service, if a workman is condemned and his services are not regularized, The assigning reasons or without assigning any reasons of terminating the service of the petitioner is arbitrary, capricious, and not lacks bona fide. In support of his contentions, learned counsel relies on the following decision. For contract, the learned counsel appearing for the respondent submits that the appointment of the petitioner was on temporary basis, temporary but contractual basis. And during the year 1998, the petitioner had applied for the post of station attendant grade 2. Said application was rejected on various grounds, including the petitioner was overaged. That the temporary employment of the petitioner was extended from time to time up to 3/1/2003. Or as the services were required by the that the temporary employment was discontinued from 3/1/2003, and the reference was filed in the year 2008. There been more than 5 years delay in raising the dispute. And the petitioner having applied to the post of attendant grade 2 during the year 1998 has not made out any ground for interference of the order passed by the labor. And the impugned order passed by the labor court does not warrant any. Having heard the learned counsel for the parties, the point that arises for consideration is whether the impugned order of the labor court warrants any interference in the present practice. The appointment of the petitioner was on temporary basis, as is evident from the appointed letter dated 11/2/1994, as per the appointed letter. As per the appointment letter 25th. What is that? Yes, yes, that will be. Where is this appointment order? Pursuant to the notification issued by the KEB on 11/2/1994, inviting the eligible candidates for appointment to the temporary post for carrying out operation maintenance work in 120 MW diesel engine power plant at Yelanta. For the post of junior engineers, the petitioner submitted his application and was appointed to the board on 11/3/1994 for temporary purely on temporary basis, for a period of 6 months. The services of the petitioner continue. Let's continue up to 3/1/2003 by VVNL as the KPTCL responding number 1 as KEB. As KEB, the year 1999 was bifurcated into two corporations, namely KPTCL and VVNL. And the KPTCL came under the administrative jurisdiction of VVNL. And the temporary employment of the workmen was extended from time to time till 3/1/2003. The petitioner workman raised dispute in the year 2007. The petitioner had to establish that on 3/1/2003, he was illegally removed from service. The material on record would indicate that the petitioner was appointed purely on temporary basis. There's also material to note that the petitioner submitted an application in the year 1998 seeking appointment for the post of attender grade. However, he was not appointed on the various grounds, and his services were continued in 3/1/2003 on contract basis. The terms of the contract clearly specifies a certain period, time for appointment for certain period, and the extension which was offered to the petitioner was due to many reasons, including the work which was assigned to the petitioners. There was no agreement of the petitioner having to be continued in the respondent part. From 2003, the date on which, according to the workman, he was refused employment, till the raising of dispute, nothing is forthcoming, with an unexplained delay in raising the dispute. The apex court, in the case of Nedula Gandhi Bank's case versus KP has held in JT 2000 Part 1 SC 388. Has held that so the law does not prescribe any time limit for the appropriate government to exercise its powers under Section 10 of the Act. When a workman has been refused employment, the establishment where he is working, the dispute should have been raised within a reasonable time. In the present case, the year 2003, there was refusal. The dispute was raised only the year 2007. No materials are forthcoming on part of the workman to indicate that he had made any efforts. Made any efforts to seek for his employment. However, the employment of the workman was only on temporary basis based on the contract. He cannot seek permanent obligation on part of the respondent. The tribunal, the labor court, by considering the said aspect, has rightly rejected the dispute. which warrants no interference. The decisions placed by the learned counsel appearing for the petitioner. The court has absolutely no quarrel that your petition. Now, of which judgment you're saying? This is Jasmeer Singh, part 2, right? Second one, 53.
Filing by earlier result.
Yes. No, we will. Negotiable and not applicable to the present. Learned counsel for the petitioner emphasizes on the decision of the apex court, the case of Jasmeer Singh versus State of Haryana, to contend that the and at para number 14, to contend that that the Limitation Act is not applicable to the proceedings under the Act, and the relief under it cannot be denied to a workman merely on the ground of delay. And that the plea of delay has to be proved by the employer by showing real prejudice and not merely a hypothetical defense. Then the counsel submits that the petitioner workman had made his demand regarding his illegal retrenchment by termination by making representation to the respondent establishment several occasions, and this aspect was totally overlooked by the tribunal. Regarding to the facts, the learned counsel submits that the labor court was not justified in dismissing the application, dismissing the reference on the ground of delay, as a delay would not bar the right of the workman, which he would have been entitled if he had approached the labor court in at appropriate time. The labor court has illegally has failed the labor court has failed to consider that the termination of the services of the workman is illegal, and raising a dispute with the delay of 4 years cannot be held to be a stale dispute when the termination dated termination for refusal of employment the workman is one which suffers from illegality. The 70.
And time of the response, the current one
That was a case where he was terminated on several occasions. The case of Bhunesh Kumar Dwivedi relied by the petitioner is distinguishable. Is distinguishable for the reason that in the said case, the temporary worker was relieved from service and terminated several times and subsequently employed again in his service. But subsequently employed again. In the instant case, the services of the petitioner was continued till 2003. And the appointment of the workman was purely on a contractual basis. The petitioner cannot seek for permanency of his appointment. And the labor court was justified in passing the order. And the court passed the following order. The petition is hereby dismissed. The appeal order passed by the labor court stands confirmed.
Much apology.
Yes.
This man, Lord, Mr. Sarkar, my lord, had a dental operation today. He had some issues with his tooth. My lord, may I request for my lord immediately after vacations for further hearing?
Yes.
Some personal
Got
inconvenience.
some dental issues or some issues, right? Anyway, we have taken it as part heard. We will complete it.
Please.
The counsel for the petitioner, and counsel so and so submits that the petitioner counsel has undergone a surgery. Alva, should we say that or no?
Inconvenience me.
Dentistry surgery. Dentistry surgery. At request list this matter on 25th for further hearing.
Please.
No. What is this month? Yes, because 18th would be not a sitting day, so Fridays we will take 25th.
Grateful.
Now the question was, where is the petitioner counsel? He was here. The question was, is there any application necessary to be filed by them seeking for resumption? That's again the question. What happens in the absence of any application being filed? It becomes automatically vests with the government, right? Correct. Then what happens? This is after 78, 2003. Then what happens? What happens? See, there is a procedure to be followed. Most probably, when a regrant has been sought, they have to file an application under section 5. In this case, the question is not about regrant. There is already a regrant. Correct. There is a regrant. There is a sale in your favor, which is during the non-alienation clause, that is of 15 years. If such a violation is there, what happens? It is automatically goes to the government. What happens after that? There is no question of limitation here. He need not even file an application, right?
Once land goes a state member, it's for the state to dispose of in accordance with law.
But then you cannot take that benefit of saying that.
Even I can make an application saying that because
You have not done that. Then
Since
what
even
happened?
the state is also not an entity.
So all of them are negligently. So what happens now? See, he is the owner. He's seeking, he got a regrant in his favor. After the regrant, after the act, that is amended act of 1978, he sells the property, which is in the year 2006. So if you take as 1978, non-alienation, either from the act or from the date when he sells the property.
From the date of the regrant.
From the date of, when was the regrant?
2006 is the regrant, to 18/4/2006 is the regrant. He executes GP on 24/11/2006. And after some 2011 and 8 there is subsequent sale. He has executed a registered GPA for formation of the layout and other development. Immediately his intention is to develop the property, not utilize as per the beneficial legislation. Lots of question, the state also did not act, my name is continuing.
This is automatic. Everything is automatic here.
The state did not take any action.
There is a violation, then automatic rest with the government. Then we can direct the government to take action.
Even to take action, then comes a question, what was the reasonable time for them to take an action?
That is not available here. Again, it's not put. See, 7A, permission. Let's come to 5A. Nobody is assisting. You all are all stressing upon only the limitation point. But then you have to tell us what happens if none of you all file and there is a violation. What happens? Either of you all, at least the petitioner counsel should make that available. You won't say because it is against you. But then what is the law you have to say, right? The act doesn't prescribe anything. 5A, right? 5-4. Now first we'll come to regrant. See. Just wait for yellow to dispute. This is the very actually 1961, right?
It's 1960.
Whether the alienation of granted land between 15 years of the regrant is by section 7A null and void, and whether the application is necessary to be filed for resumption. So even in the absence of any application filed for resumption, the sale or alienation by the regrantee is in violation of section 7, becomes null and void. So there is nothing which we have to do. Now it is with the state. So but the state has to take appropriate action against the persons who are there in unauthorized. They would be termed as unauthorized hold.
For them also to make an application, say that we serve the property and it goes to the regrant or something, that limitation also needs to be
on that basis after vesting with the land. Now they want that land has been vested automatically.
Vested in the year 2006 itself. Ah.
After when the land goes with the state in 2006 itself. 2022, my lord, they now go and say reconvey the land to 2020. It's also the doctrine of external activities will come into play because state is also not taken any action. Then my lord, the person whose name is continued has to be undisturbed on my lord, because my lord, the state, my lord, the further
Come to rule 4. Rule 4. Any transfer of land in contravention of section 3 shall be null and void. And the land so transferred shall as penalty be forfeited to the west in state government free from all encumbrances. So he'll have, the state will have, any person in possession thereof shall be summarily evicted thereof by the deputy commissioner, and the land shall be disposed of in accordance with law. So you have to take action after there is violation of this rule 5. You may be in possession, but that is not the concern. Concern is only for that reason this court took so much time now. It automatically goes.
it automatically goes down, my lord, their application of seeking reconveyance or exemption. The section, my lord, 7 is saying it's violation. But their application, my lord, may be treated as, my lord, the application. As stated in the.
Well, whether resumption application is at least necessary. No resumption here. Unlike this PTCL Act, there is an application for seeking for resumption. There is no resumption application.
State has to be disposed of with the law applicable to the disposal of unoccupied unalienated land.
Now it has to take the character of unauthorized occupants. That is unauthorized holder. You all are unauthorized holder. They have to evict you from in accordance with law.
And also, my lord, they have to dispose of, my lord, there's also one of the last rule. The deputy commissioner, the land shall be disposed of in accordance with the law applicable to the disposal of unoccupied unalienated. Still, my lord, we can make
unalienated, unoccupied, unalienated. Again, there it doesn't say transfer unoccupied, unalienated land to the disposal of unoccupied, unalienated in accordance with law applicable to the disposal of. No, that is for the deputy commissioner to do whatever he wants. But then, as of now, his application itself was not necessary.
Also, question by all of us are negligent in what has to happen. So the state is also deemed to take action and because permitted for us to conversion. Subsequent said Tahsildar did not prevent one of the all.
We don't know what all happened there.
Because even the conversion, everything is permitted. Therefore, Muller, the doctrine of physics, Muller, can be or waiver, Muller, the themselves waiver of the state. Because Muller, substantial very parties' rights have been created. They all
Again, only for that reason this court is looking. But then if you look into the law, there is no provision for anything there. It straight away says alienated, non-alienation clause, forfeit to the government, rest with the government.
There is no application for them to seeking exemption as
There is no resumption there.
Only applications for regrant. And all the provisions says if the regrant is wrong, then section 5.
So regrant cannot be wrong because you are claiming your right under the regrant order itself.
Only Muller thing which is not goes to the state. And the state did not take any action. The subsequent transaction, all these things, what state, if they did not take any action, what has to be happened, that's one point. Land vested the state
Not yet convinced. You have to play something better than this. You have to say that though the alienation was within a period of 15 years of the regrant, then the transfer which was made during that non-alienation period, though the deputy commissioner the land forfeits to the government, in light of no action being taken by the petitioner or the respondent state for evicting you from the premises, there is a right of acquiescence or waiver by the government and the petitioner for not seeking for resumption. The resumption, again, there is no resumption.
This junction, my lord, the question of limitation would come, my lord, if the state has not taken action for 10 years. And they can allow to go on, my lord, the flow the blood, my lord, water. Well, but what was the situation, my lord, what was the time limit for them to take an action?
What was that? Where does it mention?
That is
Nothing.
no- that is-
See, there's nothing for them. They have to just forfeit. It comes automatically to them. Whatever sale has been done, it is void.
They did not do, my lord, when action comes, my lord, what time they can do?
No, that direction we can give them to take action against you.
We
For,
allow them to take the action, my lord, but
Ah.
the question of limitation, when they can take, my lord, many occasions, my lord, even in the 79 AMD, my lord, there was such occasion, my lord, after many years of the sale, and even, my lord, the land tribunal granted my land, after some years, they will issue a notice that the land was granted by misrepresentation of fraudulent act. For that also, my lord, the question of limitation has come into picture, head of the person who has granted the land.
you have to give some substantial law regarding this.
Regarding that portion, my lord, and 7A, whether that will automatically go
You have to say that.
But provision is.
What you say, now the government has not taken action against. What happens? Even assuming you need not file a resumption application, you need not do anything. Your application itself was not maintainable. What happens? See,
The land is available.
such event, re-grant. Re-grant to any person who is eligible. Even you would not get that. You had already been re-granted. No, the government within what time has to take the possession? What does the prescribed time is? What is the time prescribed under the act? 7 year. What does it say? So Commencement Act is 2003, and the re-grant, whichever is there. Now, even if you take 2003, also you don't come. Any land disposed of or re-granted under subsection 4.
It was more first, right? That's also like, automated also. Then of permission.
So once if you say this transfer is not proper, it's in contravention, then that gives you penal provisions also.
They did not take any action. That's the only point on what I.
What happens? It is like state has to take, he has to automatically seek for possession from the unauthorized holder and then issue again one more order of re-grant to the person. Whoever eligible. But your right would go all the time. You have no right now.
There is a violation. Yeah, no, it's not being, there is, 6 is, police concern. Police concern. Now, it is the knowledge of the government that the violation was there.
No, that is available to you when government initiates action, not at this stage. This stage is only, this is,
Filed by an official before the was, these kind of, what you call, that is restoration of the application is not made.
they need not even file resumption application. That is what we are saying.
Yes, that so actions, that is also not been taken by the government of last.
Now, this is not the case where we have to say about government anything. What we have to say, the property vests with the government in light of the violation. Now, there is a violation here during the period either 2003, either 2003 or 2006. When there,
Date of violation.
because Amendment Act 2003, even if you take this 2003, the sale was in the year 2006. So if at all there is a sale, there is a violation and that sale becomes null and transfer becomes null and void and the property rests with the government. So as on today, you have no right.
Or, permission granted.
Otherwise, we'll set aside this order, direct the respondent number 1 to consider and pass appropriate orders. Is it not? Not at this stage now. Please let him consider the provisions of section 5(4) and 7(a).
So number 2 of the government or the Tasha's order.
What is that? Tashidar's order, huh? ಅವ್ರು ಸುಮ್ನೆ 15 years ಅಂತ ಹೇಳಿ
Yeah, petition itself is not maintainable. Tasha has no jurisdiction to do with it.
if we say that the application is not maintainable, the sale itself was void in light of section 5(4), the property vests with the government, we have to say now. We will say that otherwise. Automatically it goes. There's nothing.
Next question.
Next question is.
Part of the government.
Extraction would come to you, available to you when they take a possession from you, not at this stage. You get me some proposition where we cannot issue such direction to the respondent. State only would be silent. Now you have to substantiate. Will it say that you will be benefited by that? No, that cannot be a void document. You cannot say like that. Adverse possession, then government will say something else.
You cannot say adverse possession because it's something else, not 30 years over.
You cannot take a plea of adverse possession also. You are the owner. Because in light of the sale.
After completion of 30 years, you can take it on some other loan, but 30 years is not over. March mistake.
You are not a government to take 30 years. It's only for the government. But somehow it appears they are entitled. The application, we have to say the resumption application itself was not necessary for them because automatically 5(4) makes a right. Correct. That is why then what happens? Automatically vest with the government.
That is the application.
No, then if you say, see, in light of section 5(4), the sale what they have made in favor of you is null and void in light of section 5(4). The property vests with the government. That's all we have to say now. And what the government has to do, let them take action in accordance. Is it not? On that point,
that may know if they did not take it because it
That is for them to take, let them take its course in due course. This court had to, in spite of you not telling this, we had to look into whether there is any provision for them for making resumption. When it is, because all this time we were under that 63 and 78 enactment only. If there is a sale deed between 63 and 78, it has to be saved. Light of this Lakshman Gowdas and Bashir Ahmad. But now this is not that case. You knowingly, this is 2006.
Partition. Partition.
A permission illa. Otherwise, the petition has to be.
Comparison of the other.
No, not dismissed. Has to be allowed. We have to say that though they have filed a resumption application, it was not necessary for them to file. They need not even file a resumption application because automatically by law it has been vested with the government. Have you been granted re-grant order after the vesting of the land with the government? No. No, this will again we will forget about it. So that's why we don't want to kill this land.
What should happen?
So you are agreeable to the proposition of law 5(4) says vest with the government. So there's nothing further to be done. Automatic. There's no resumption application. I don't know why they have filed that application also. No, that cannot be given. That cannot be granted. It has to go to the government. It has to go to the government. Naturally, by force of law. By force of law, automatically it goes. So this is the, I think for the first time such a thing is coming. That is available to you when they take the possession or they seek for regrant. You can raise all the contention before this state.
Someone tells over on the spot.
Because there are once you know about it, I just have a comparison of all those knowledge. At this point, I just want to. The doctors or some doctors may come in.
This is rule 5, no? Rule 5.
Subsection 4. So section
5.
Section ala, rule 5.
Section.
Section.
Yes, section 5.
So don't. Neither he will get, neither you will get. It has to go to the government and the government has to take appropriate action. That is all. That is what, under what circumstances they have given you, they have kept quiet. That is not our concern. And you can raise that. Now they at this stage, they cannot say, even if it is vested with the government, automatically by section 5(4), they are not available for them to take possession of that. Then authorized holder anta alli hogbeku. Unauthorized holder. Alva. 2M. Means a person in possession of a land granted or continued in respect of or annexed to a village office by the state without any right. Now you have no right. Or under any lease, mortgage, sale, so and so, or any kind of alienation, therefore, which is null and void under the existing law relating to the such village. So we have to look into section 2N and then direct the state government to take recourse in accordance with law. What is that you will convince this court after this? Automatically it goes. That is already stated in 5.4. That is something which you have to do before this date. They are in possession. Who are in possession?
Society has taken it from works in it, purpose has been allotted.
That is now your headache. Is it not?
State, that's why I just want some. That's what it made little knowledge about the clause in which.
Little knowledge, you have confused the court to
No,
little knowledge.
But I just want some research on it.
25th for further hearing. With an understanding that if you don't give anything, we will learn. Yes, yes. Huh? Of course, it's already a partnered matter. 25th for further hearing. The book referred to. Yes, yes, Mr. Then, what was the loss? What was the loss sustained by them? Anything adjusted to that loss? There is no loss. 230, na? 232. You have to say what was the loss sustained, any loss, whether you have any forfeited that amount with that, and whether this rents can be taken as in that earlier petition, you have not sought for forfeiture. You did challenge the forfeiture in that earlier petition. The first order. Passover at 2:30. Yes, Mr. Channakeshwar. ಎಷ್ಟು time ಬೇಕು ಖಾಲಿ ಮಾಡ್ಲಿಕ್ಕೆ? You have to tell the time. Now see, this is high time. Paginda. 81. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಹೇಳಿ? 40? 40? Sale deed ಆಯ್ತಾ? What sale? Agreement. ಮತ್ತೆ? This is for admission of final year. What is the substantial question? ಇಂಥದ್ದೆಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಾರ್ದು, ಸ್ಟ್ರೇಟ್ ಅವೇ ಬಂದ್ ಹೇಳ್ಬೇಕು. Hearing. But their plaintiffs being the phone. They are. ಅವರು ಟೈಟಲ್ ನೇ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀರಾ? You dispute their title. When was the sale agreement executed? 81. And did you raise this plea before the trial court? Did you raise that plea? ಇರ್ಲಿ, ಡೈವರ್ಜೆಂಟ್ ಇರ್ಲಿ, ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಲ್ಲ ಈಗ.
withdrawal admitted.
Yes. ನೀವು agreement of sale ಅಲ್ಲ ನಿಮ್ ಫೇವರ್ ನಾಗ ಇದೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ did you make the averment in your written statement? ಅಲ್ಲ ಮಾಡಿದ್ರಾ? Then before the first appellate court? ಎರಡು ಕಡೆ. Did you file a suit for specific performance? Then you want to take protection. 53A. Senior counsel, yeah, she is designated senior counsel. Then ಎಷ್ಟು ಸಲ ಇದು ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಮಿಸ್ಟರ್ 81 81 you are from 81 you are residing in the premises as a tenant 85 ನಲ್ಲಿ you take a plea of agreement and that also you have not ಒಂದ್ ಮಾತು ಹೇಳಿ ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಪ್ರಶ್ನೆ ಕೇಳ್ತೀವಿ ನಿಮ್ಗೆ ಉತ್ತರ ಹೇಳಿ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ನಲ್ಲೂ ಹಾಜರಿರ್ಲಿಲ್ಲ ನೀವು where were you residing? ನಿಮ್ದು ಅಡ್ರೆಸ್ ಇನ್ your cause title of your appeal memo ಯಾವ್ದಿದೆ ಅಡ್ರೆಸ್? Please come to your cause title. Please come to your cause title. Same address ಹಾಕ್ತೀರಾ? ಕಾಂಪ್ರಮೈಸ್ ಮಾತಾಡಿ ಅದಕ್ಕೆ ಎಷ್ಟು ಟೈಮ್ ಬೇಕು ಖಾಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿ. Heard in part. This matter on 25th for further hearing. ನೀವು ಟೈಮ್ ಕೇಳಿದ್ರೆ ನಾವು ಟೈಮ್ ಕೊಡ್ತೀವಿ ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಇಂಪೋಸ್ ಕಾಸ್ಟ್. ಎಸ್ 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 ಮಿಸ್ಟರ್ ಅಭಿನವ್. ನೀವು ರಿಲೀಸೇ ಮಾಡ್ಲಿಲ್ಲ ಅಂತೀರಾ ಈಗ? and what you said about it? ಎಷ್ಟು ದಿವಸ ಇವರ 2002 ನೀವು ಹಾಕ್ಬೇಕು ಅಫಿಡವಿಟ್. ವೇರ್ ಇಸ್ ಯುವರ್ ಅಫಿಡವಿಟ್? No, what is not received by you? 7 crores. 55 crores is not. That is they have already stated. Now we asked you to file an affidavit that whether you have released or not. They say that they have not been received. Where is your affidavit with that? This will go on. This is of the year 2002. When the SCGP seeks time to file affidavit in compliance with the order dated 18/9/2020. That request was a final chance. 2 weeks time is matter. Is this matter in the week commencing from 21st? Until we have said specifically further hearing, please, we will not insist. Yes, Mr. Abhinav.
That should have been another repetition has been withdrawn. So that pointed out, like after an order copy also.
Now in light.
The repeat
petition that they mentioned to earlier.
Correct.
That's the ground, not a point at which.
Now, in light of the objections you have they filed, they said, right, you have not raised this, your contentions was not raised in that earlier petitions, right?
Annexure G is under challenge.
Now you are seeking for withdrawing of this petition with availing the liberty to file. Let him go before the appropriate authority.
2016, he filed a writ petition. Now he wants to. They filed it.
They realized only when.
Express not.
But they realized only when you filed your objections and they thought they'll go for the alternative. Petitioner seeks to withdraw the petition with liberty to file the appropriate remedy available to him in accordance with law. The memo is taken on record. The petition is disposed of with liberty to the petitioner to avail the alternative efficacious remedy before the appropriate forum in accordance with law. News taken on record. You want the limitation. That is always available to you. You cannot say that. We will transfer that amount to the appropriate. Is amount in transfer.
At least for a period of 30 years, as part of the demand.
It's not deposited here. It is
paid for. Therefore, at least for a period of 4 weeks, if it may be extended, then you have available.
We will extend another 2 weeks. If you have deposited before the spot, if you deposited before the spot, how does she? Memo for you. What is your memo about? 50%, where did you deposit? Before the spot. 50 petitioner has 21/6, no? So for another 2 weeks, we will continue this order. But then for 2 weeks, we will say.
So after all these years and having withdrawn the other challenge, main challenge.
Understandable. Of the deposit made by the petitioner to the extent of 50% before the court in compliance of the order passed by in compliance of the interim order. The court feels it appropriate to extend the interim order by a period of 2 weeks from the date of release of this order. Only 2 weeks. Amount in deposit to be transmitted to the appropriate forum. Counsel for the petitioner, Abhinav. What is your name, Mr. Counsel? Where is he? You senior counsel. Huh? Yes. Sriranga. We don't know which appropriate forum, right? But then once he deposits.
If it takes statutory remedy or not, by statute is liable to deposit.
So 126, right? 126. What is the appropriate forum under 126?
It should be the CGRF, not.
So you are approaching the CGRF, right? Seeks to withdraw the petition with liberty to approach the CGRF under section 126 of the Karnataka Electricity Act 2003. Permission is accorded. The amount in this deposit to be transmitted to the CGRF. CGRF. Yes. So let it go before that. Yes. Yes. B group. That is an passover. Passover. Yes. GC Prabhakar Adjournment.
I appear for the respondent, my lord.
It was urgent in the morning hour, right?
38, my lord.
Yes, we have not heard this, right, Mr. Srinivas?
No, my lord.
You take your chance after vacation,
Very well, ma'am.
after Dasara vacation 2024.
Very well.
Yes, Mr. Sarojini Muthanna, did we hear this petition? Was it heard? Was it heard? Did this court hear this? No. So you take your chance after summer vacation. I mean Dasara vacation. After the Dasara vacation. After Dasara vacation 2024. Yes. Akshita Shetty. Where is Mr. Devraju? Yes. To reach this matter after Dasara vacation 2024. Pronouncement. Yes, Mr. Shekhar, ಏನ್ ಮಾಡಿದ್ರಾ ನೀವು ರೀಕನ್ಸಿಲೇಷನ್ ಹಾಕೊಂಡು ಏನಾಯ್ತು ಆಗಿದ್ಯಾ ಯಾವ್ದು ಸೆಟಲ್ ಆಗಿದೆ 9 and ಅದಾಗಿದೆಯಾ 9 ಹೌದಾ let she come then we'll take it up in the afternoon ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳೋಣ ಬರಲ್ವಾ ಕನ್ಸಿಲೇಷನ್ ಅಲ್ಲಿ ಆಗಿದೆಯಾ ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ ಗ್ರೀನ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು ಇವ್ರ ಗ್ರೀನ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು ಗ್ರೀನ್ ಶೀಟ್ ಇಲ್ಲಿ ಇಲ್ಲಿ ಹೋಗಲ್ವಾ ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ ಅವ್ರಿಗೆ ಸೈನ್ ಮಾಡಿ ಅಂತ Krishna Corporation joint memo is filed by both the councils stating that the corporation has agreed to reinstate the respondent workman into service with continuity of service. The joint memo reads as under 1 to 4. In terms of the joint memo, the writ petition stands disposed of. Petitioner corporation to reinstate the workman within a period of no directions also. The joint memo is taken on record. In terms of the joint memo, the writ petition and the order passed by the labor court, the order stands modified. Yes. 40 million interim order granted earlier is extended to the next date of hearing. 40. ಇದೇನು 21235 ಯಾವ್ದದು? You have given one more matter. ಅದು ಯಾವ್ದು? ಇದು joint memo same 9 and 14. Urgent ಬರುತ್ತೆ ಅಲ್ಲ ಬರ್ಬೇಕಲ್ಲ ಅಷ್ಟರಲ್ಲಿ ಎಸ್ ಇವರು ಸಂಜೀವ್ದೆಲ್ಲ ಆಗ್ಲಿಲ್ವಾ ಆಗಿದ್ಯಾ ಅದು ಅರ್ಜೆಂಟ್ ಅಂತ ಮಾಡಿದ್ವಿ ಬರ್ಲಿಲ್ಲ ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ಬಸವರಾಜು ನೀವು ಬರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿವೆ 5 settled. ಏನು joint memo? Sanjeevna joint memo. Both the consuls are filed. Joint memo is filed by, duly signed by the petitioner and consul for the petitioner and the respondent. The joint memo reads as under 1 to 4. The joint memo, in terms of the joint memo, the writ petition stands disposed of, and the award stands modified. 5 alva, 5 alva. Next one. 1 3. ಅದರಲ್ಲಿ settled. Same joint memo ಕೊಡಿ. Consul for the petitioner and respondent from joint memo, which reads as under 1 to 5. In terms of the joint memo, the writ petition stands disposed of, and the award stands modified. Award stands modified. Yes, Mr. Ramesha idare adralli. But the constants find the joint memo, which reads as under. In terms of the joint memo, the writ petition stands disposed of, and the order of the labor court stands modified. Stands modified. Next. Proceeds after vacation. And then about 10, 11 and 12, what happened? Shekhar, 12. 12 settle aita. 18021. Joint memo filed by both parties, which reads as under. The petition stands disposed of, and the award of the labor industrial tribunal stands modified. The petitioner corporation is directed to comply, directed to pay the arrears within a period of 4 weeks. 4 weeks. Arrears tane? Arrears alva? Arrears. Compliance to be done by the corporation within a period of 4 weeks from the date of release of this order. Which was the serial number? 12. 18. ಇದು compliance, ಇದು taken on record, ಎಲ್ಲ ಒಂದು. Compliance by the corporation within 4 weeks. In terms of the 16. This is compliance, compliance joint memo, which reads as under. In terms of the joint memo, the writ petition stands disposed of, and award of the industrial tribunal stands modified. The petitioner corporation to do the compliance in terms of the joint memo within a period of 4 weeks. Yeah. ಅವ್ರು ಬಂದಿದಾರ? The 2. We will not release until the signed by the party. Sign ಮಾಡ್ಲಿ ಅವರು corporation. ನಾಳೆ ಮಾಡ್ಲಿ. ಸೈನ್ ಮಾಡಿದ್ಮೇಲೆ ಇದನ್ನ ಮಾಡಿ ಕೊಡಿ. Both the consuls are fine joint which reads as under. In terms of the Joint memo, the writ petition stands disclosed now and or passed by the principal and district judge session, so it stands modified. ಈಗ ಕಂಪ್ಲೈನ್ಸ್ ಇಲ್ಲಲ್ಲ? ಇಲ್ಲ ಕಂಪ್ಲೈನ್ಸ್ ಇಲ್ಲ ಇದರಲ್ಲಿ. Counsel MC Baswaraju submits that he is filing wakalat for the respondent today. Office to show the name of indicate the name of MC Baswaraju in the court list. Is this matter after the Slavic? This. So you have done good job of settling. Ellaru reinstate ಆದ್ರಲ್ವಾ? ಅಲ್ಲ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಪಾಪ ಏನ್ ಮಾಡ್ಬೇಕಲ್ವಾ ಅವರು? ಹೌದಾ? ಸೆಟಲ್ಡ್. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಉಳಿದಿದೆ, ಅದು ಮಾಡ್ಬಿಡಿ ನೆಕ್ಸ್ಟ್ ಇದ್ರಲ್ಲಿ. ಸಣ್ಣ ಸಣ್ಣ ಆಫೆನ್ಸಸ್ ಇದು ಮಾಡ್ಬಿಡ್ಬೇಕು, ಮಿಸ್ಕಂಡಕ್ಟ್. ಅದೇ ಒಂದು ಪಾಠ ಅವ್ರಿಗೆ ಫಸ್ಟ್ ಟೈಮ್ ಡಿಸ್ಮಿಸಲ್ ಎಲ್ಲ ಮಾಡ್ಕೋಬೇಕು. ಅವ್ರಿಗೆ ಗುರ್ತಾದ್ಮೇಲೆ ಅವ್ರು ಮಾಡಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡಿವಿ. ನೆಕ್ಸ್ಟ್ ರಮ್ಯಾ HN ಅಂತ ಇದ್ದಾರೆ 14 ನಲ್ಲಿ. ಅಲ್ಲ ಕರೆ ರಮ್ಯಾ ಅವರು ವಕಾಲತ್ ಹಾಕಿದಾರ? ಅಲ್ಲ ಕರೆ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ರಮ್ಯಾ HM. ಅವ್ರು ವಕಾಲತ್ ಹಾಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿ. ಅದು ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ HR Renuku undertakes to file power for the petitioner. A week's time is granted to file wakalat. Order sheet ನಲ್ಲಿ. No, but then our wakalat ಬೇಕಲ್ವಾ? Yes. Absolutely. Any urgent matters? Tomorrow afternoon we have yes, Mr. Counsel. 2:30. 2:30. Total. That is at portal, right? Portal. Where is he? Standing counsel. What is his? What is his instructions? Have you produced a notification, Mr. Vaibhav?
My lords, lordships have it at 2:30. My lords, I'm ready, my lords.
So that notification is there. Just look into that. What is that? Pronouncement आदमी.
Point of order, the number 42, Chandra Hasmi.
You're for the petitioner in this plot.
Ah. Under such circumstances, upon regrant, the title of the predecessor of the respondent hearing would relate back, and the alienation affected would inure to the benefit of the alienee, who would get good title of such land after the regrant by applying the principles of reading the grant by estoppel, as held by the full bench, where the alienation occurred between 1/2/1963 and 7/8/1978. The alienee would not be an unauthorized holder, and in the said circumstances, the point framed for consideration is answered accordingly, and this court passed the following order. The petition is allowed. The impugned order dated 2/7/2020 in MA number 31 of 2017, passed by the respondent number 1 at Annexure B, are hereby set aside. The sale deed dated 16/11/1966, registered on 26/12/1966, to the extent of 1 acre 20 guintas, is confirmed in favor of the petition.
Grateful note.
Concluding bench. Hearing on item, serial number 1, Kiran Patil.
Yes, Mr. Patil, what is this correction?
Lords, I appear on behalf of Shivanand Patil. There's some technical error due to which he is not able to log in. It may be taken up after vacation. He will personally log in.
What is this correction he has sought for? From JMFC Chincholi to Senior Civil Judge Yadgiri. What we have done is reflected that the diverse petition be transferred from Yadgiri to Senior Civil Judge JMFC Chincholi, despite the prayer seeking transfer from Senior Chincholi. It has to be interchanged.
Please, Your Lord.
It cannot be IA for amendment. It has to be IA for correction.
Please, Your Lordship. It may be taken up after vacation, Lordships. I will inform the council.
No, we will allow this application. It is just a transfer of the name, correction of the name. We'll order it.
Please, Your Lord.
Is in the I1 of 2 of 2024. It's filed for correction of the judgment. In the operative portion of the judgment, it is mentioned MC 38 of 2022, pending on the file of Senior Civil Judge and JMFC Yadgir, is withdrawn and transferred to the Court of Civil Judge and JMFC Chincholi, which has to be stated as MC 38 of 2024, pending on the file of Senior Civil Judge and JMFC Chincholi, to be withdrawn, is withdrawn and transferred to the Court of Civil Judge and JMFC Yadgir. Necessary correction to be made in the operative portion and to release the order by the registrar. Accordingly, allowed. Yes, Mr. Mahajan.
In the judgment, in all the places, the extent is properly shown, except, my lord, for page number 7 and in the operative portion at page number 17. The first line, my lord, in page number 7, the extent is shown as 8 acre 23 guntas. It should be, my lord, 8 acre 22 guntas. Your lordship, my lord, has recorded the extents properly in just below 3 or 4 lines, my lord.
Number 7, page number
7, first line, my lord, in the corner, right hand side corner. 8 acre 23 guntas it has come. It is required to be, my lord, 8 acre 20 guntas. So also, my lord,
22 guntas.
22 guntas. In the operative portion, the same extent has come, my lord, as 8 acre 32 guntas. It should also be 8 acre 22 guntas.
I-1 of 2024 is filed for correction of the judgment. In page number 7, it is to be mentioned as 8 acres, 22 guntas instead of 8 acres, 23 guntas.
In the first line, my lord.
In the first line. And in the operative portion,
in the operative portion, point number 2, my lord, the third line, 8 acre 22 guntas instead of 8 acre 32 guntas.
and in the second paragraph,
Yes, my lord.
we
The
mentioned 8 acres, 22 guntas instead of 8 acres, 32 guntas. Okay. And after making necessary correction, registry to issue a text copy. Yes. Accordingly, I-1 of 2024 is allowed.
Obliged, highly obliged.
Obliged.
Yes.
Now this appeal parties compromise.
All the parties are present.
All the parties are present. But there are 3 points, my lord, which are in the cause list. First is, my lord, that the compromise petition signature of respondent number 2 in the compromise petition does not tally with that of the signature of in the wakalat. My lord, his self-attested the Aadhaar card is also furnished. And Lord, it appears, my lord, over a period of time, the signature may have changed or varied, but my lord, the council on record is identifying, my lord, so that should not be a major concern.
So it is insofar as respondent number 2. Respondent number 2, Alva.
Respondent number 2, my lord, his name is Machandra, my lord.
Respondent number 2, R8, R9A, and RD, right?
No, my lord, respondent number 2 signature is not tallying. And my lord, respondent number 7, 8, 9, my lord, I have filed a memo for dismissal of appeal against them. Because respondent number 7 and 8, they have filed, my lord, a written statement along with the appellant's hearing, where it is admitted, my lord, that the suit scheduled property has been given to the branch of the appellant's hearing. And my lord, they have not joined in filing the appeal also. No appeal, my lord, relief is sought against them. And my lord, they have also not filed an appeal. So therefore, they are not necessary parties. Point number 3, my lord, is regarding memo of dismissal of appeal against respondent number 7, 8, 9, my lord. It is in that regard, my lord, they have not signed the compromise petition. Now, by virtue of this compromise, my lord, what the parties have agreed is that, my lord, we are acknowledging, my lord, that the contesting respondents who are the plaintiffs from the trial court, they have, my lord, 1/3 share in the property. Their rights are acknowledged. In lieu of, my lord, they are acknowledging the rights, my lord, instead of giving the property to them, we are, my lord, paying a sum of rupees 19 lakhs.
19 lakhs to respondent number?
To the branch, my lord, of respondent number 1 to 6 together, my lord. Who belong to the branch of Venkatrao, that is respondent number 4.
Where do you get the genealogy?
Genealogy, my lord, is that. Page number 6 of the appeal memo.
6.
Lord Madhav Rao, he had 3 sons. Govind Rao,
yes,
Venkat Rao, and Vishwanath. Now, Lord, this branch of Vishwanath was represented by Puthalaj Bhai and Danaji. They, Lord, have admitted that the suit schedule property to the share of Govind Rao. It is stated, Lord, specifically in page number 5 of the written statement. It's a matter of record. Now, Lord, though the suit is decreed and the regular appeal is dismissed, they have not preferred an appeal. Now, my lord, who remains now?
Dependent 4 and 5 have not preferred any appeal.
They have not preferred an appeal because
So
they have already on record admitted, my lord, that the property is belonging to the branch of Govind Rao. Now, the branch of Govind Rao, my lord, are appellant before your lordship. Now, Venkat Rao's branch, my lord, is Venkat Rao, Gulchan Bhai, Sanjeev, Shivaji, Machandra, and Gorakh. All of them before this honorable court, my lord. The compromise is now between the branch of Govind Rao and branch of Venkat Rao.
Yes.
Now, your lordship may see, my lord, Dasharath, defendant number 8. He did not, my lord, join us in filing the written statement. He did not contest the suit, nor did he, my lord, file a regular appeal, or, my lord, he did not join in the second appeal also. Now, this amount, my lord, is being paid by two sons of Amrut Rao to the branch of Venkat Rao. Defendant number 6 sons. Now, defendant number 6 is no more. His two sons, my lord, are paying the entire amount, 19 lakh rupees, to the branch of Venkat Rao.
Now you say that Dashrath will not be entitled for anything what you will be allotted in this part, in this compromise.
Yes, my lord. In this particular property, he may be entitled, my lord, for share with respect to other properties. But as far as this compromise is concerned, it is, my lord, this, Amrut Rao's sons, they are, my lord, literally purchasing the property by paying amount to the 2/3 share, my lord, which is entitled to the branch of Venkat Rao. My lord, branch of Venkat Rao, we are acknowledging that it has 1/3 share. Now, 1/3 share of Venkat Rao, it is literally, my lord, they are purchasing. This context, my lord, Dashrath may not be necessary party, and, my lord, the branch of Vishwanath may not be a necessary party to this compromise petition.
Branch of Vishwanath, which is that other branch?
Lord, branch of Vishwanath, my lord, Putala
Yes, as he has already said that Govindra is, so he has already stated in his written statement.
They failed with us, my lord, in the trial court by stating that the suit schedule property, this particular property, which is the bone of contention, it belongs to the branch of Govindra.
Now, what is the compromise now? 1/3 you are giving it to the branch of respondent number 1 and 3. Yes. What is the
that the trial court had decreed the suit only with respect to item number 8, my lord, which is shown at page number 3. It is admitted, my lord, that this branch of Venkat Rao has got 1/3 share. In lieu of that 1/3 share, my lord, instead of going for partition by meets and bounds, my lord, this branch of Govind Rao, represented by, my lord, by the sons of Amrut Rao, they are, my lord, together purchasing this property by paying a consideration amount of rupees 19 lakhs.
etc. That is the respondents 1 to 6. Have to accept 19 lakhs towards their undivided 1/3 share and to relinquish their 1/3 share in favor of appellant number 1B, who is dependent number 6. Dependent number.
Sons of, my lord, defendant number 1B and 1C, they are the sons of defendant number 6.
Correct. And then in turn, the appellant 1C, in lieu of 1/3 share of the branch of Venkat Rao, dependent number 1C, have agreed to pay a total sum of 19 lakhs. So you will be paying that amount on behalf of this family, right? Govind Rao, or for only Amrut Rao?
My lord, the arrangement is such, my lord, that all of them have agreed that since, my lord, the only two sons of Amrut Rao are paying the property, they will exclusively grant the property insofar as this suit schedule property is concerned. Because the other persons are not contributing. They have all signed the compromise petition with an understanding that henceforth this property, survey number 279/D, would be, my lord, the exclusive property of appellant number 1B, Balaji, and appellant number 1C, Jnaneshwar. Because
so now the branch of Dashrath, you want to contend that they have not contested the suit, neither contested the appeal, neither filed any appeal before this court. So you have no relief against them.
We have no relief against them, my lord. Had they come and joined, my lord, in paying the amount, probably they would have got some share in the property. Now,
in the event they come forward and pay that amount to you, will you give that share to them?
It so happens, my lord. Now there is an arrangement, there is a decree, my lord, of the trial court, which is upheld by. Insofar as 1/3 share of the branch of Venkat Rao is concerned, my lord, it remains intact because we have also admitted that the branch of Venkat Rao has 1/3 share. Now there is an inter-alia arrangement between the branch of Venkat Rao and, my lord, the contesting appellants.
So the suit is one for declaration against the branch of the branch of Govind Rao. Govind Rao.
This was a suit for partition.
Partition. So in the event now that you are relinquishing you're paying the amount by taking that 1/3 share from the branch of this Venkat Rao. But they are saying that you will be declared as owner in respect of this property. That is Amrut Rao and even Pandit Rao? No. not Pandit Rao, only Amrut Rao. Insofar as Dashrath is concerned, what happened?
Dashrath may not, my lord, his right may not arise because it is the undivided, my lord, interest of Venkat Rao. This particular person, my lord, these two particular persons are purchasing.
You want to give away the right of that Pankaj Rao in respect of the property. And what could survive is again a dispute between yourself then.
Now, what would happen, my lord? Survey number 279D is concerned. We are admitting that, my lord, Venkat Rao's branch has 1/3 share. Now, it's now being compromised. The branch, my lord, 1/3 share of Venkat Rao, which is, my lord, is literally being purchased by these two persons, will be the exclusive property of these persons. Now, the other 2/3 remaining share, that, my lord, will always be open for them, my lord, to seek partition because the properties are not divided.
Yes. Yes, who are the parties now? Where is the parties? Respondents 1, 2, 3.
Respondent.
And where is Amrut Rao?
Lord, Amrut Rao is no more, my lord, LRs are recorded. Keshav Bhai, I will call them, my lord, by one by one. Keshav Bhai. Lord Keshav Bhai is present. Balaji. 1B, my lord, Balaji is present. Dhaneshwar.
This is 1A Keshar Bhai. Keshav Bhai.
Keshav Bhai, she is present. Ek Hatu Chula.
Balaji.
Khalikara.
Dharaneshwar.
Dhaneshwar, yes.
And then Shailaja.
She is present.
They are the LRs of Amrut.
Now, Pandit Rao also there, my lord. Pandit Rao.
Pandit Rao.
He is there, my lord.
Yes. Anna Rao.
They are present.
And who is the plaintiff?
Plaintiff, my lord, are the respondent number 1, 2, and 3, my lord.
Sanjeev Kumar.
Sanjeev Kumar. Sanjeev Kumar.
Machandra. Gorakh. You have placed the affidavit of all the parties? Or you have the Aadhaar card?
Self-attested Aadhaar cards are filed.
And then who is that person you were mentioning? They were aged about 90 years or something?
Now, my lord, Venkat Rao is 90 years old. Venkat Rao.
Venkat Rao has nothing to say in this petition because he has already stated that Govind Rao, right? No, Venkat Rao is defendant number 1. He is present. So his branch is Sanjeev, Shivaji, and Machandra.
Sanjeev, Shivaji, Machandra, my lord, his wife is Gulshan Bai. And the other sons, my lord, other son is Shivaji. 1 to 6, my lord, they belong to the branch of Venkat Rao.
And where is this Gulshan Bai? Gulshan Bai.
She is present, my lord. Gulshan Bai. She is present, my lord.
Where is the compromise petition? And I-1 of 2024 is filed. Compromise petition is filed under order 23 rule 3 of CPC. The compromise is entered between appellants and respondents.
Lord, if I may.
1 to 6.
Handing over the check may also not be.
Just a moment. You don't hand it over now. Just a moment. The family genealogical tree is stated as an page number 4. The appellants are from the branch of Govind Rao, namely Amrut Rao, Pandit Rao, Pandit Rao. Amrut Rao died during the pendency of the appeal, and his LRs are brought on record as appellants 1A to 1D.
1D.
1D, Alva. Shailaja also is there.
She is daughter, my lord. She is 1D.
1D. Pandit Rao. Pandit Rao and Anna Rao. First, Pandit Rao and Anna Rao. Respondents 1 to 6, 1 to 3 are the 1 to 3 are the plaintiffs from the branch of Venkat Rao, and defendants 4 to 6. Respondents 4 to 6 are defendants 1 to 3 from the branch of Venkat Rao. And respondent number 7, Putlabai, is the wife of Vishwanath, the third son of Madhav Rao. Tanaji, defendant number 5, respondent number 8, Tanaji is defendant number 5 from the branch of Vishwanath. Next. Defendant number 8, respondent number 9, Dashrath, son of Govindra, is deceased, and his LRs have been brought on record as respondent 9A to 9B. Dashrath is from the branch of Govindra, brother of Amrut Rao and Pandit Rao, bracketnally defendant number 6, Amrut Rao, Pandit Rao and defendant number 7. He did not contest the truth, and against the decretal of the suit in OS number 104 of 1994, awarding one-third share, the appellants along with Putlabai and Tanaji preferred appeal. No appeal was preferred by defendant number 8, respondent number 9. Memo is filed by the appellants seeking to dismiss the appeal against respondent number 7, 8, from 9A to 9B, which reads as under. The memo is taken on record. The appeal is dismissed as against respondent number 7, 8, 9A to 9D, as no relief is claimed against the appellants. As no relief is claimed by the appellants against the said parties, and they belong to the branch of Govind Rao and Vishwanath. In light of the same, the office objections raised by the registry is overruled. Signature of respondent number 2 is stated to be varied in the compromise and in the wakalat. Does not tally. Counsel for the appellant, counsel for the respondent number 2 acknowledges the signature of respondent number 2 in the compromise. Memo compromise. As per the compromise, the terms of the compromise reads as under. Para 9. Para 9. Para 9, 10, 11, 12. 13. In terms of the compromise, the second appeal stands disposed of, and the respondents 1 to 3, Alva?
Please, madam.
Respondents 1 to 3.
1 to 3. Machendra, Sanju Kumar, Machendra, Gaurav.
Respondents 1 to 3. Respondents 1, 2, 3, and dependents also, right? Dependents 1. Plaintiffs 1, 2, 3, and dependents 1, 2, 3. Or the respondents 1 to 6. 1 to 6. Acknowledge the receipt of the DD, na?
My lord, there is one DD for 5 lakh rupees. There is cash, my lord, of 5 lakh rupees, and my lord, a post-dated check for the remaining 9 lakh rupees.
Have you mentioned it in your
Please, my lord.
compromise?
Please, my lord.
Where is that?
I have stated, my lord, in the compromise petition that amount would be paid subsequently, my lord, but to show bona fides, my lord, I'm handing over the check today itself.
Handing over the amount as compromised in at para as stated in para number 12. Okay. 5 lakhs of cash.
Recorded, my lord, that the check.
By one draft dated 15/7/2024, bearing number 295673, drawn and SBI, and 9 lakhs been paid through how much? 9 lakhs.
Through,
By
my lord,
check.
post-dated check.
Check date, check number.
Check number, my lord, 687 983.
9?
687 983.
67983.
My lord, 687 983.
To an amount of rupees?
9 lakhs.
Amount of rupees 9 would be subject to the realization.
Post-dated check, my lord, dated 1/11/2024. my lord.
Post-dated check dated 1/11.
2024.
Subject to realization. Then appellants 1 to 3 and respondent number 1 to 6 are present through video conference. Duly and their presence is acknowledged by their respective counsels. Presence and identified by their respective. As both the counsel submitted that since the parties, more particularly Venkatrao, was aged about 90 years, they could not physically be present before the court, and their presence was taken through video conference. The registry of this court is directed to send the Xerox copy through email, the order sheet to the Kalburgi bench to obtain the signature of the respective parties in the order sheet, and the said order sheet to be placed before the court, placed and form part of the order. In terms of the compromise, the appeal stands disposed of. The compromise petition would form part and parcel of this matter. Yes, Mr. Mahajan.
Obliged, my lord. Highly obliged.
Yes, sir.
A very old dispute comes to an end, my lord.
Yes.
Highly obliged.
Yes. Kindly give the Xerox of the check, Mr. Mahajan, along with the memo.
Forthwith, my lord, I shall do it. I'll file it in the counter, and also, my lord, I'll hand it over, my lord, to the registrar.
We will be sending the order sheet through email now. Just take a printout and then the registry will do the needful. You take the signature of the parties. Yes.
Highly obliged.
Good.
Number 1 for P group, Shekhar.
Yadu disposed of. Writ petition stands disposed of. Including petitioner and the respondent have filed joint memo, which reads as under 1 to 4. The writ petition stands disposed of in terms of the joint memo, and the order of the labor court stands modified. Good work, Mr. Shekhar.
That's the one.
Copy. We furnish the notification.
It has gone all the way to the Supreme Court for the past 10 years, my lord. The single issue is only.
The government is already ready to open up the military state. But as it would be, but the central government would be obligated to open up the and do it. No, announcement comes and says you're going to pay objections. That notification is not there. That is why there is a detailed order passed.
We look into this objections. We'll take it up. So we have to, it's not just passing an order, right? We have to look into it. We will list it immediately. Objections are filed by the respondent. List this matter immediately after Dasra vacation in the week commencing from 21st. Not, we have vacations in the week commencing from 14. Yes, we cannot give a date. Let us see. Yes, 14. The week commencing from 14.
Number 10.
Yes, Mr. Jaisimha. Disconnection, connection ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ? ಕೊಟ್ಟಿದ್ದೀರಿ connection. Then why did you withdraw his connection? G ಪ್ರಕಾರ ಏನ್ ಮಾಡಿದ್ರೆ disconnection notice ಮಾಡ್ಬಿಟ್ಟಿರ ಅವ್ರು. It is already disconnected, Mr. Consul. Already disconnected. Without any coercive, with coercive steps ಅಂತ ಹೇಳ್ಬೇಕು. Without ಅಂದ್ರೆ ಹೆಂಗೆ? Stay of annexure G. G na G. SCGP, no. You appear for room 1. KPTC, na? You are not knowing for whom you are appearing, madam. SCGP to accept notice for respondent number 1. HV Devraju accepts notice for respondents 2 and 3. The Then a counsel for the petitioner submits that pursuant to the order dated, pursuant to the notice at annexure G, the respondents 2 and 3 have disconnected the electricity connection of the petition premises by using coercive measures and without any lawful order, and only on the pretext so that their civil dispute is pending. Not against, when the civil dispute is pending against whom? Civil dispute in respect of the property is pending. The electricity supply being the basic necessity of a citizen. The act on part of the respondents 2 and 3 at annex as indicated at annexure G cannot be accepted, as the petitioner was given with the electricity connection. RR number kodi, bulk kodi. RR number K4 T722, and the impure notice directing disconnection and pursuant to which the disconnection has taken place. The state respondent number 3 is directed to restore the electricity connection forthwith, and subject to the petitioner paying regular consumption charges. Yes, Mr. Somsekar, settlement. ಏನಾಯ್ತು? Where is she present? It one screen. She is able to stand, see? You ಮತ್ತೆ ಇಲ್ಲಿ afterwards she will say that she was not even. Huh? Okay. Iರ್ಲಿ. To be on the safer side. Joint memo ಕೊಡಿ. Joint memo. Madam, what is your name? Saroja. Sabita Pujarti. Yes, you accept this compromise, this settlement. Madam Sabita.
ಹೋಗ್ತೇನೆ ಸರ್ ಮೇಡಮ್.
The joint memo is signed by the petitioner Sabita Pujarti and the registrar of Manipal Academy of Higher Education. Manipal. Huh? Yes, he is your registrar, right? The terms of the compromise reads as under 1. 8. The General Secretary of the Petitioner Union is present before the court. The petitioner Sabita Pujarti, on whose behest the dispute was raised, is present through video conference in the establishment, and she is present in the establishment of in the respondent establishment, is duly identified by the petitioner counsel. Identify ಮಾಡ್ತೀರಲ್ವಾ? In terms of an amount of, and check to who is paying it? Check for DD na? Check the amount of rupees 5 lakh. Bearing number 049990 is handed over by the petitioner to the, in the name of Sabita Pujari. In the name of Sabita Pujari, and is handed over to the General Secretary who is present before the court. Our Hesarenu Purushottama. Purushottama is present before the court. In terms of the joint venue, the writ petition stands disposed of, and the award of the CGIT from Labour Code stands modified. Modified, alva? Yes. Modified. Subject to realization. Check packet in subject to realization. Madam, the check is handed over to your General Secretary. Madam.
Okay, madam.
Yes.
Number 15.
Number 3.
After arguing the matter, madam, is it permitted? Is it permitted? Will your senior counsel also acknowledge that? Is it proper? After arguing the matter, otherwise you should not have argued it, right? But then when you came, we thought you are the senior counsel, right? Is it not? We are not. We don't know as to who is the. We don't know as to who is the senior counsel. The colleague mentioned that the senior counsel is coming. You came in a rush. You argued the matter. We thought you are the senior counsel. Is it proper? Is it proper, madam? Yes. Who is this? Yes, senior counsel. Yes. What do you say? Is it not? Is it?
That's the reason why it's
Not fair. At the first instance, if you would have mentioned a senior counsel is coming, we would have happily given you a passover. You would have taken up the matter. You were understanding the. Anyway, you both of you will go to the mediation center. Till then, we will stay the impugned order for some time. See, it's a breathing time to them, not an impugned. We are not considering on merits. We are looking into the nature of dispute between the parties. We can understand. Madam, we can understand if it is somebody, a third party. Your sisters. You know, a sister is more like a mother. Will never come.
When the license has been revoked.
We understand all. You may be having 100. No, you may be having.
Equitable in nature.
Correct, because your sister is equitable. Your elder sister, moreover.
This petitioner has suppressed that.
That may be.
That form is resolved. They have taken a stand that the license is the name of the form. We didn't say that. Right, if it may be taken, your lordship, the license was revoked from 17.
When was the license issued to them?
15th of July, which I get to know on 11th of September when he started to inform me. Then 3 days time is given for me to give a response. I had my response saying I had never sought for any renewal. I license copy the letter as well, reference letter as well. Renewal application dated 5th of June.
So you want to do something against your sister, that's all.
No,
you want to do something against her.
Within the petition, ganging up against, they should have respected her. 4 people are ganging up against one lady who is 87 years old.
And she is. And what is the age of the petitioner, madam?
The petitioner is not running Bhagan side respondent number 4. She is not getting a single rupee. Accounts are not being made. Karnataka Cinema Regulation Act says tenant cannot be promoted. It is an admitted case of the petitioner and the pleading that tenant.
You go before the mediation. Looking into the nature of dispute and the relationship between the parties. The parties are referred to the Bangalore Mediation Center. Mediation Center. Bangalore. Yes. On 14th. Not to take any coercive actions. Not to implement the order of
You already see that there. Now then.
Till then, no coercive actions to be taken by respondent number 2. Respondent coercive, not to take any coercive ಅಂದ್ರೆ ಅದಾದ್ಮೇಲೆ ಅವ್ರನ್ನ ನಿಮ್ಮನ್ನ ಹೊರಗೆ ಹಾಕುವುದು ಅವೆಲ್ಲ ಮಾಡಲ್ಲ. Not to take any coercive till the next date. ಮಾಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇವ್ರೆ. Otherwise both of you all will not do.
There are 2 points for mediation. 2 properties. That may also be included.
No, that is for you to say before the mediator. How can we go and say that? So now the court is restricting itself to only the extent of mediation for this petition, not about the other properties. You can always be at liberty to settle there. Not to take any coercive action till the next date. Respondent number 2. SCGP notice ಮಾಡಿದ್ರಾ? ಕೊಡಿ file ಕೊಡಿ. Just a moment. We will give notice to you. Enter caveat, right? SCGP to accept notice for respondent number 1 and 2. So counsel has entered caveat for respondent number 3. She accepts notice for respondent number 3. Issue emergent notice to number 4 returnable by. So we'll not issue notice to respondent number. Petitioner to take out hand summons on respondent number 4. The petitioner and respondent number 3 and 4 to be present before the Karnataka Mediation Center on 14th at 2:30. On 2:30. At 2:30. And then respondent number 2 not to take any coercive action. 16. Yeah, you were strong enough. Yes. You should not identify yourself with the client. You should just make your submission and let it go. Yes. No. See, we will not look at you and pass orders. We'll look at the papers and pass orders. Okay. Fine. Yes, what is this? 1 second. Not to take any coercive action pursuant to the order dated 17/9/2024. Respondent number 2. Yes, not to take precipitated steps. No, till then, see, nothing will happen. Pursuant to the order. We will not say anything. Let it be this way. Not to take any precipitative action pursuant to the order dated 17/9/2024 till the next date of hearing. Liberty is reserved to the respondent to make necessary application for vacating or modifying the order. Yes, Mr. Narayan Swami, ಏನಾಯ್ತು? Settlement ಆಯ್ತಾ? Somshekhar has taken the initiative, so everything happens in a good way. ಆಯ್ತಾ? ಆಯ್ತು ಬಿಡಿ. Affidavit will dispose of this petition in terms. So you are not claiming any other reliefs, right? Affidavit is filed by the, where is she? So we have to appreciate her.
ಬೆಳಿಗ್ಗೆಯಿಂದ ಮತ್ತೆ ಜ್ವರ ಬರ್ತಾ ಇತ್ತು ಅದಕ್ಕೆ
Affidavit is filed by Anjulila Ramani, the Chief Operating Officer in the responding company, stating that the gratuity amount as claimed by the employees,
The union,
as claimed by the petitioner union, the responding company is ready to pay the gratuity by May 2025 as per the Payment of Gratuity Act, who are not willing to report for duty. And further, the employees should resign from the service and withdraw the charter of demand case ID number 59 of 2017 and ID 92 of 2017 regarding transfer. The petitioner submits that in light of the undertaking affidavit given by the respondent by the Chief Operating Officer, the petitioner does not press the present petition, and the petition should be disposed as in terms of the affidavit. And accordingly, this court passed the following order. The writ petition stands disposed of, and the respondent to pay the gratuity to the employees, petitioner's employees alone of the union by month of May 2025. The resign and the petition and the employees to withdraw the charter of demand and the transfer case pending. Pending before the industrial tribunal in light of the affidavit. But a direction as in light of the affidavit, the respondent to pay the gratuity amount by month of May 2020. Writ petition stands disposed of. The affidavit is taken on record on copy. Chief Anu was present before the court in the morning hour. The affidavit is filed in the afternoon session. Sequence what happened? Where is he? No representation for the appellant. Call this matter after 2 weeks. Where is your yes, please. We'll hear him anyway. Now that we'll hear him for some time. We just wanted some clarification. Page number? Yes.
Please. Get the order. Go to the region. The new market area.
Mr. G.K. Bhattavara, you have to tell us how this rents can be forfeited, can be adjusted to that forfeited amount. Andre,
this is an order of those needed to not for failure to furnish the but for failure to furnish a third bank guarantee and also current.
Andre, as per the terms, you could not comply, so you were forfeited.
Yes.
Now, I want to know.
This order was forfeited.
Before the
number 90018 which was regularized by granting the installment.
Really, which is that writ petition?
I pass away.
You have not produced that writ petition yet.
Here it was. The 2018 so this was first time under the key petition. So the next order of December 4. First year alienation. First year the back to the case, and then an offer by the petitioner that he is really able to pay more. That's tomorrow.
But that was an interim order, Alva.
And by installment as granted by the order. The earlier platform was made and say, but here, and this order also is a subsequently order. The government and the Canada, which is the last 3 years. The government itself made an order.
Yes.
The third line, bottom third line. And they only,
Not very legible. Yes, yes.
negotiation to model ಸರ್ಕಾರವು ಮೇಲ್ಕಂಡ ಆದೇಶ ಖರೀದಿಸುವ ಮುನ್ನ ಮೊದಲೇ ಗುತ್ತಿಗೆದಾರರು ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿಯನ್ನು ತಿಳಿದು ಬಂದಿದೆ. It is referring to the order dated 17/11/2026. So before this order was enforced, the bank guarantee was published, arrears were paid. ಇದನ್ನು ಖಚಿತಪಡಿಸಿಕೊಂಡು ಒಂದು ವೇಳೆ ಇದು ನಿಜವಾದರೆ ಯಾವ ದಿನಾಂಕಗಳನ್ನು ಮೂರನೇ ಬ್ಯಾಂಕ್ ನಾವು ಮಾಹಿತಿಯನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ. ಸರ್ಕಾರಕ್ಕೆ ಏಕ ನಿರ್ಣಯ ಎಂಬ ಒಂದು ಕಾರಣವನ್ನು ಬಹು ಟ್ಯಾಕ್ಸ್ ನೀಡಲು ತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ. All the parts of the government. How much time is the last one? Government was running, and this was not cancelled. For the last 1 month, the petitioner was either asked to continue or in a new person. By way of negotiation, continue.
Sarva Samadhana scheme is still when?
November or December. Yes, for the whole of the year. Now there is this security amount and permission is extended. There is no yes. There will be no liability of interest.
But then we have already deposited that
First is bank guarantee amount. You got it their own document, very clear.
one second. When was the contract cancelled?
17th November.
18 November?
Seventeen
1711?
The month of July itself.
But when was that cancelled? 2017? 2003. So after that there was re-auction?
There was a negotiation. Negotiation is there with the neighboring country. The meeting neighboring country. Now, already that also I think.
See, now the amount which is sought to be recovered by the respondent is the arrears of rent. Okay. Rule 18(2) forecases that EMD forfeited can be adjusted to the loss sustained. So it cannot be adjusted. In the instant case, now the claim made by the petitioner is to adjust the rents, whether that is permissible.
You should go for last 3 months time.
Where is that rule? No, this rule 18 will not come to your aid. Rule 18, because the EMD which was forfeited can be adjusted only to the losses.
Punishment. Typically says that it should be adjusted for last 3 months rental because last 3 months rental, he should keep it in his pocket to go for the next year of fund.
Where is that? Lease of the right of retail vendor, no? 1976, huh? Correct.
It is made out of 3.
Page number ready?
19 mechanism.
Page
number 565. This page.
Rule of
forfeited in all of the business will be adjusted over the final monthly dividend payable by
rule ಯಾವ್ದು rule?
19.
ಈ rule ಅಲ್ಲಿ ಇಲ್ಲ page 565 ನಲ್ಲಿ ಇಲ್ಲ. Rule 17. 19. Rule 19.
Under forfeited. In accordance with these rules, it will be adjusted over the final monthly payable by the person to whom the
All deposit unless forfeited. Under forfeit ಆಗಿರಬಾರ್ದು.
So, This is adjustable. In this case, final monthly rent, etc. Why this theme of this rule
Literally forfeit ಆಗಿದೆಯಲ್ಲ forfeit
ಆಗಿಲ್ಲ. In this government has immediately update that when the government says that even before that order will be enforced, they will only be granted. There was a delay of over 15 days.
Let's see, where is that? Page R1.
Only forfeit master.
ಮತ್ತೆ ಮುಂದೆ ಅದು ಇದು facts and circumstances.
The government has to the elections of December before, this government order the letter dated 24 March 2003. As the date 17/7/2003. Now the candidate is reference Sarkari Adesha Sankhya.
Why don't you give a synopsis of all these dates along with this which you are producing? Alva, if you give the entire synopsis, it would be more easier for the court to in the notes form nalli. You say that in this petition, this is the order, and what was the earlier order, and which is the order which you are challenged earlier. Give the details of it so that it will be more. Any Friday, yeah. Only on Friday. Friday 2:30 at on 25th. 18th is a holiday. It's a non-sitting day. So the coming Friday only it will happen. So earliest is 25th. Please give a synopsis. Both the petitioner counsel to furnish the synopsis by 25th. This matter on 25th. Along with the forfeited, when was the date of forfeiture, and according to the government, when they said that it's not forfeited, and also the notes regarding whether the rents which has been claimed by them can be adjusted to the forfeited bar non-forfeited amount. What was that? All that details. Yes. Next, further hearing. Further hearing on 25th. Yes. Thank you, Mr. Japar. Yes.
What is earnest money?
Correct.
To establish the sincerity.
Yes. UMD. Yes, yes.
Passover matters. Then number 8, punishment guarantee. Then sheet of correspondence.
Didn't need it, right? All after the revocation.
Then number 10, instances.
ಯಾವುದಿಲ್ಲ ಅದನ್ನ adjournment. No appearance for the petitioner. No appearance for the petitioner.
Then number 15.
No appearance for the petitioner. Yes. Did you know to put the question? That you can mention before the mediation itself. So now that you can tell them in advance so that they can make arrangements. Is it not? As of now, let them be present. We will say so, and you say the presence is not possible due to that reason. They will give you the provision for the release.